That's all.
My lord, yesterday I have mentioned, yesterday I have mentioned one matter, my lord has directed to list today, my lord. It is not came in the list, my lord. Not in the list, my lord.
Order is going to be expired today. Item 65.
Come before rising of the court. Come.
May I just
My lord, yesterday I have mentioning the urgency, my lord.
yesterday night, several people might have out my house claiming for the pending money only due to the unfreeze minute. I do not have any money in my savings left. My business account is closed. This is the
What can be done?
My lord, yesterday I have mentioned, my lord, regarding NEET examination, my lord.
Mentioning date, come tomorrow.
My lord, yesterday I have mentioned regarding my lord NEET examination. My lord has directed to list this matter today, my lord. It is not came in the list.
I will go to the office and collect your file.
My lord, files are there, my lord.
If I will go,
My lord, files are there, my lord.
If it is there, it will be listed. When the court has passed an order to directed the list, it will be listed. If it is not, it is not.
unnecessary.
Every day you cannot mention before this court.
My lord,
This case has been will be filed. Only
What the police jurisdiction is not before this court.
No,
my lord, my lord, this is a, my lord, it's a very urgent matter, my lord. My lord, my client has been coming from New Jersey to meet his father who is in his deathbed. But she was not allowed to see in the PLS hospital. My lord,
Who is
this matter will be fixed urgently, my lord. Plaintiff, your lord. So I appeal for the petitioners.
Considering the facts and circumstances of present case, this court finds that even if the passport is renewed, the petitioner will not be in a position to leave India without prior permission of the criminal court, and the passport will remain in the custody of the criminal court. If the petitioner intending to go to abroad, the petitioner has to obtain permission from the court. Thus, it would be appropriate that instead of renewal of the passport of the petitioner only for 1 year, the passport authority shall renew the passport of the petitioner for a normal period of 10 years from the date of its issue, subject to compliance of all formalities within a period of 3 weeks from the date of receipt of this judgment. After renewal of the passport, the petitioner shall strictly comply with the order passed by the criminal court dated 9th October 2025 and 13th October 2025 by surrendering the passport within 5 days from the date of its renewal.
Oh, great for your lord.
My lord, I am for the petition.
Here I set aside both the orders, verification committee as well as adjudication committee. I remanded back to the adjudication authorization committee to consider within a week and to pass appropriate order by considering the statement recorded through video recording as well as the affidavit submitted before the judicial magistrate. No, disposal. Both disposal.
This come out, my lord, instance, my lord.
Yes.
The petition, my lord, where there was a writ petition, my lord, where there was a challenge, jurisdictional challenge, my lord, to my lord notices. My lord, the interim order, my lord, was passed, my lord, in this matter. That was, my lord, until, my lord, today. And, my lord, I don't know whether, my lord, there.
We are not in the
Till 5th of August, until further. Who is further? Yes.
Yes.
Opposition
Is not yet ready.
Not yet?
Ready. Your lordship.
Yes. So what do you want? Extension?
Extension, if given your lordship, then is okay. But in instruction, we have not received any instruction.
You not received which department? UCO Bank?
UCO Bank, your lordship.
Kind of, my lord, a long extension so that, my lord, they can file, my lord, the affidavit. So, my lord, coming, my lord, repeatedly, my lord, asking for, my lord.
So you will file affidavit or not?
Yes, your lordship. We will
When?
file.
Tell me. How much time?
At least 3 weeks, your lordship.
3 weeks.
And, my lord, the interim order, my lord, now, my lord, should be till disposal, my lord. I don't know. It's so, my lord, coming, my lord, every time, my lord. Every time, my lord, coming.
What is the nature of the interim order?
My lord, there was challenge, my lord, 2, my lord, notices, my lord, which were issued, completely barred by limitation. My lord, it's a jurisdictional, my lord, issue.
Fraud. Fraud.
No. My lord, this is, my lord, invocation, my lord, against the guarantor after, my lord, 10 years.
Okay. Recorded.
On the face of it, my lord, barred by
The Learned Counsel appearing for the bank prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 3 weeks. Reply, if any, that we filed within 2 weeks thereafter. Full stop. Counsel for the appearance submit the interim order is till today and paid for extension of interim order. Interim order is extended, and this court find that the petition is enjoying the interim order since
disposal of the
since the finding of the application. According the interim order is extended this till 5 weeks बोला ना till 23rd September 20 no,
My lord,
until
Lord,
disposal of the
Lord, kindly, my
petition
lord,
result.
till the disposal of the writ application. List the matter on 24 September 2026 under the heading adjourn motion. Adjourn.
and 3 weeks, my lord, and my lord, we've
3
got
weeks, 2 weeks.
2 weeks.
Can 10 has been disposed.
Can, my lord, is
Can 10 disposed of.
Wait.
This is my writ application.
It is a chamber party then.
No, this is my writ petition. Your Lordship will recall Mr. Trivedi was appearing, my lord, for the Union of India. Yesterday, I have served him another email, my lord. His junior, in fact, called up my advocate on record and said that they'll be there. I do not know, my lord, why. Because that's the only person.
Lordship, I am being led by Mr. Bhattacharya, who is appearing for
They
state.
are for the state, my lord. They are not the answering
We have
respondent.
filed the
In
report.
fact, the
by law.
banks are also not answering respondents. The union is. But only, my lord, given the compelling circumstances, my lord, I press for having Your Lordship to hear the matter out, my lord.
Yes,
But I'm
what's the
suffering, my
matter?
lord. Yes.
Appearing on behalf of the respondent, Union of India, my lord.
Respondent?
Respondent, Union of India.
Union of India. Yes,
Yes.
you are the person. You clarify whether this notification is prospective or retrospective.
My lord, the instruction has
Not instruction, you submit it. Giving the one paper instruction, that's our appearing.
My lord, kindly come paragraph 3, Roman 6, my lord, idle portion and 4. Roman 4, my lord, paragraph 3, Roman 4. Serial number 1, DRT Kolkata. Total, in the last, total pendency 8,981. DRT 2, 3,866. DRT 3, 13,169. But in Siliguri, only pendency 612.
What is this matter?
Have you given the copy? Give the copy.
অভিযোগ পরে দিয়ে দেবেন
ফোন নম্বর নিয়ে বের করবি কেন?
আপনার কাছে সফট কপি আছে পিডিএফ আছে
পাঠিয়ে দাও।
মামলার সময় তো আমার লাগবে এখন
My lord, kindly come. Last paragraph, 6, paragraph number 6, the transfer of the case.
আপনারটা থেকে
Has not caused any prejudice to the petitioner. The rights and liabilities of the parties remain unchanged. Only the forum before which the matter is to be adjudicated has changed. It is a settled principle of law that no litigant has a vested right to insist that
Tell me, government has issued notification. Who will transfer the case? Who is the, because a new court has been established. Earlier case was with the earlier court.
My lord.
Who passed the order for this case is to be transferred to this? Who is having the authority?
At this stage, I can.
Huh? Who is the authority? I appreciate with regard to the notification, no problem.
My lord.
But who will pass an order for transfer of the case? And how, without any transfer of the case, how the Siliguri bench has issued the notice, how file went there, which order? Tell me, you are appearing for the Union of India. Mayor appearing on behalf of the Union of India will not serve the purpose. That's why this court has issued the notice to the ASGI.
I apologize.
No, I am asking, since beginning telling I am for the Union of India, well, you give the answer.
So my.
Sir, you wonder which order?
Yes, Mr. Trivedi, here the only question,
Yes, Lordship,
how this notification give effect prospective or retrospective? First thing, and second thing is it is retrospectively or prospectively. So after the notification, which authority will pass an order for transfer of the case from one forum to the other, one court to the other court?
well, the instructions which we have.
Because here what has happened, okay, notification, immediately the Siliguri has issued the notice. How the matter went to the Siliguri? Which order?
Lordship, as far as the instructions are concerned, Lordship, what we have got is that they have issued this particular notice under section 3.
Section 3, that's
That they have issued.
notification. He has not challenged notification.
Then, Lordship, they are saying, Milaj,
Yes.
that because at Siliguri, DRT, the workload was much less compared to the Calcutta. So therefore, they have done that. Now, Lordship, what has fallen from my Lord is giving it retrospective effect. In prospective, Lordship, it has fallen that yes, you can do it, or that is not his challenge. He has come as his right in personam, not in rem.
Yes.
He is not challenging the notification legality, saying that why the pending matters before the Calcutta bench were transferred to Siliguri, unnecessary creating problems for them. Now, Lordship, I can join, I can make submissions, Milan, but then that will not be, because what is falling from my Lord is a point which I need to assist my Lord, not to unnecessarily rake out section 22 of the Debt Recovery Act, that he has an alternative remedy coming to Whirlpool's case. All those preliminary points I will take. But then my Lord will kindly not take me amiss, my Lord, on this aspect. If my Lord gives me a breather of a day or two, my Lord, I will.
That is only, see, two questions.
Well, I have got it. One, why, how you have given it retrospective effect.
Yes, he's not challenging the notification.
Lordship.
So virus gone.
Lordship.
So now only with regard to if it is there retrospective or prospective. First thing, okay, it is prospective. So who is the authority to pass an order for transfer? Because it is case before the one particular court. There will be some authority. The one court has established directly, the court cannot say the file may be sent to me.
Lordship, they are saying that Lordship, this particular notification says that all the matters should be transferred. They are saying plain and simple that. Therefore, I am not handing over the. If my Lord may. একটা instruction copy দিন না আপনার জুনিয়র কোথায় একটা instruction copy দিন my lord को instruction একটা copy দিন না no
there is no transfer, there is no order of transfer, only this particular having
instruction there.
Instruction is there.
Lordship, we got the instruction.
As per your instruction, you are justifying with regard to the establishment of the court. There is no problem because that is not the issue here. Only kindly see the page 174 of the writ petition. 174 of the writ petition.
Petition copy দাও আমার কেউ
Or you take time, no problem. You take when you will come.
Lordship, but it is not about coming, Lordship. Well, points. Lordship, what is being challenged, Lordship, I just want to understand what is falling from my lord. My lord is saying that this notification, you have all the right under the sun to pass this notification, it is not under challenge. But Lordship, twofold questions have fallen from my lords. One, retrospective and prospective effect.
Yes.
That has not been denoted in this particular notice. So the matters which are already pending before the learned Kolkata bench, how could those matters be transferred? This is one. Second aspect what has fallen from my lord is that how does the Honorable Siliguri bench gets the power, because there is no such notification or giving him power to take the files onto his, because there should be a procedure for that, that all the, so those are lacking. So we have to satisfy your lordship on those 2 points.
Because-
My lord will give me a breather for 2
Because-
days period. I shall.
Because if the notification provides,
My lord,
all the cases of that will transfer,
My lord,
there
My-
would be no problem
lord.
at all, but it is not provided.
I'm grateful.
If, might be misreading, you can,
My lord, this is what we are trying to rectify. My lord, because statute in its wisdom has something to say we don't know. We understand it through judicial debates between the honorable bench and the officers of the court. Then we try to fathom out that how to solve the teething problems of any notification. Because execution is a different ball game altogether, while
But the
legislation act. So, my lord, then it is we do the work of making it effective and executing in a prim and proper manner. So these are the questions which have fallen from my lords. My lords, I will surely appraise your lordship very humbly, my lord. I shall,
when,
my lord, subject to yesterday, my lord, subject to my lord's diary. I should not say, because my lord's diary is always overburdened. My
come
lord,
on
it will not take much time. My
Tuesday,
lord.
Tuesday?
My lord, it will not take more than 5 minutes.
That's
because my-
only the
Yes, my
things
lord.
are
So, my lord,
required.
My lord, at my lord's pleasure, my lord.
And you also take, if the parties intending that this case will continue, what would be their,
my lord, first, if they don't have, my lord, first of all, my lord, either if they don't have, they don't have, my lord. Then under those circumstances,
that will
whatever
continue.
falls from my lord. And then maybe they will rectify it later if it is in that fashion. Or if they have, my lord, we are
Yes, that's-
they're well versed with all the answers.
Learned Council for the Union of India filed report. Learned ASGI prays for time to take instruction. According cases adjourned, let the matter appear on 11th August within 10
My lord,
minutes.
I am hearing for the state one by additional Attorney General, my lord, there was a direction to the additional Attorney to be present, my lord. The last occasion, my lord, it was it. If your lordship is, my lord,
Call the matter.
Most grateful, my lord.
Your brief is with me.
Number 5 and 6, my lord, I beg to
You look up.
my lord. My lord, before my landed senior, my lord, starts, my lord. I advise your lordship to seek your lordship's leave to my lord. Relatedly use one counter affidavit.
Well, there cannot be a counter exception. Number one, ECL and GM, there seem to be some understanding or misunderstanding. ECL comes and says that everything has got stalled, and GM keeps on improving and we are changing their case. But yesterday we have been served with
I may, my lord, explain, my lord.
no,
Although
cannot
my
be
lord,
a completely a new case.
This was, my lord, affirmed on, I shall be more candid to your lordship. This was affirmed on 31st of July 2026, my lord. But no, not 35 July, my lord. It was affirmed on 29
June.
26, my lord. My lord, it was kept, my lord, with us. My lord, there was a deliberation and discussion as to whether this is at all required to be used or not. And my lord, in the meantime, my lord, there was a change of instructing advocate. So, my lord, yesterday, my lord, in the evening, my lord, it was decided to, my lord, to bring it to your lordship's notice and to seek, my lord, leave of your lordship to, my lord, use this affidavit.
What do you want to bring?
My
on
lord,
record?
in the exception, my lord, they
Ah.
have, my lord, challenged our technical report. They have, my lord, said that so far as the technical report is concerned, my lord, that is not at all good. And my lord, to explain that, my lord, we have, my lord, used this affidavit. That what the way, my lord, their technical report was, my lord, explained in the report. You know, to answer that, my lord, this report is my lord, only to that extent. This matter may also be, my lord, argued are good. My lord, if your
Where-
lordship are at all
Where
requested
is
that-
Mr.
that-
Dasgupta?
He's on his way, your lordship.
Yes, he's having urgency.
Yes. And a complete
Time
new
and again,
case.
yes.
Complete new case in the affidavit which my learned friend
Yes, my lord.
seeks to.
My lord,
How you can change the stand by
Yes.
my lord,
supplementary?
no change in the standard.
But I'll demonstrate that. I'll demonstrate.
I can, my lord, explain, my lord. There is no change whatsoever, my lord.
Okay.
Well, previously, the case was the first case, but this is the rather third case. The first case, immediate response was that time is over, therefore no further indulgence for you. So matter stands resolved. This was the first response. The second response, Millard, in the report was that you ought to have saved and then proceeded to the next stage. Today, the case is that this cannot be redressed at all. Kindly have a look to paragraph 6.1. But please take note the fourth line, irrespective of whether GEM help desk remotely accessed the petitioner's system through any desk, it was neither logically nor technically possible for the help desk to encounter or verify the same error. So this is a new case. This is because by the time the petitioner approached the help desk for assistance, the bid submission deadline had already expired. Consequently, the help desk could not access the same bid participation interface, etc., etc.
Yes.
Now, Millard, your lordship may kindly Millard, take Millard their original report, paragraph 7. But here they say, Millard, the time had expired, or Millard, we had approached after 2 p.m. because the time was still 2 p.m. Now, please take Millard paragraph 7 at page 3. I humbly submit, what has found it? GEM's Millard report.
Paragraph 7, yes.
Yes. I humbly submit that in order to successfully participate in a bid, a bidder is required to complete each stage of the bidding process in the prescribed manner. In the present case, the petitioner was logged out of the system as it failed to complete the mandatory stage of bidding process, as is evident from the video recording between 108 and 124 submitted by the petitioner to the help desk. So, I had Millard approached the help desk once at 108 and second time at 124 to the help desk of the respondent number 4. The aforesaid video recording is annexed such and such. Now, kindly come back to me at page 4 at paragraph 6.1 today.
That's why I'm comparing.
No, completely at variance. Complete variance.
That much I can explain, my lord. Not at all, my lord. I can
But if
explain.
your learned friend intends to use it, not subject to your lordship's permission, but I should get an opportunity to deal with it. But my first prayer is, my lord, kindly do not accept this. But if your lordship is pleased to accept it, my lord, then, my lord, I should be given an opportunity. Otherwise, my lord, since, my lord, the ECL is in urgency, I can quite appreciate. My lord may hear out the matter today, my lord,
My lord,
without
May
this.
I have, my lord, 1 minute of your lordship's time to explain that there is no at all variance?
No,
1
no,
minute.
that's
1 minute
correct.
time.
But,
My lord,
but
they have.
that's correct. The court cannot deny for acceptance. If you give that, then they have to get an offer. Then the main
Yes.
see in between both.
But I am the only person who has not at
My lord,
In
What
between
is
both.
happening?
kindly, my lord, give me 1 minute time to, my lord, demonstrate that there is not at all, my lord, variance as my lord explained by my learned senior friend. Can kindly see, my lord, paragraph 7
Yes,
of my original report.
correct.
Kindly see, my lord.
Yes.
I humbly submit
Ah.
that in order to successfully participate in a bid,
Ah,
a bidder is required to complete each stage of bidding process
correct.
in the prescribed manner.
Correct.
In the present case, the petitioner was logged out of the system as it failed to complete a mandatory stage of the bidding process as evident from the video recording. Now, my lord, kindly see, there is a bracket between 108 and 124 submitted by the petitioner to the help desk of the respondent number 4. Now, my lord, this is happening after my lord 2 p.m. The video recording, my lord, which has been submitted, that was, my lord, happening, my lord, after 2 p.m. That is, my lord, also evident from there, my lord. That is the timestamp of the video recording. Now, my lord, kindly comes to my lord page their email at my lord page 352. Their first email kindly comes to my lord at that is my lord volume 3.
So what is the necessity of this supplementary?
Well, that I will not explain. Now kindly comes to this. I just want to satisfy lordship, my lord.
Page?
Page 352.
Yes.
This is my lord their first email, the very first email. With due respect, we would like to inform you that we were trying to submit our subject bid today between 12:30 p.m. to 1:45 p.m. However, whenever we attempted to verify the OTP at the final stage of bid submission, the GEM portal automatically logged us out and redirected us to log in the page. This issue occurred repeatedly despite several attempts from our side. A screen recording of the issue is attached for your kind reference. So, my lord, what we have stated in paragraph 7 is in reference to their email that was, my lord, shot at 2:06 p.m. After the bid was over, the bid timing was, my lord, till 2 p.m. So, my lord, it is not the case of the petitioner that they have, my lord, ever approached the GEM help desk before, my lord, 2 p.m.
Then what is the requirement of improving his
My lord, categorically, my lord, stated that we cannot.
Correct. It is your specific case in the earlier exception, earlier report that in terms of 352, the petitioner admitted that he has been logged out for within 108 to 124. So, and he has made a complaint to you by a mail on 2:06 p.m. Correct. 2:06 p.m. This is your case.
She was logged out during the video recording, my lord, which
correct. 108 to 124.
But I just don't know why they are dragging the feet. My simple accept my bid online, offline.
2 minute videos timestamp, my lord.
See, if you read 352.
Yes, my lord.
What the 352 say? Like to inform you, we are trying to submit our subject bid today between 12:30 to 1:45 p.m. However, whenever we attempted to verify the OTP at the final stage of the bid submit, the GEM portal automatically logged out. Correct. Here, 12:30 to 1:45, they have tried but logged out. Now, kindly come to your reply. Paragraph 7.
Yes.
First report.
Yes.
First report, you say that participants they required to complete each stage of the bidding process in the prescribed manner. No problem. In the present case, the petitioner was logged out of the system as it failed to complete the mandatory stage of bidding process as it is evident from the video recording from 108 to 124. So your case is that he has already logged out. He has not clicked what we say. He has logged out. He has not entered into that. That's why he can subsequently after completion of the time at 2:26 he has made a report. That's why you cannot entertain. It is your case.
My lord.
Correct.
My lord.
So now what you want to improve in this exception further?
The exception, my lord, what we have stated is, my lord, so far as this exception is concerned, in the exception, my lord.
6.1, kindly come to 6.1.
My lord, 6.1, my lord, we have dealt with their allegation that they have, my lord, tried to, my lord, put up a case that as if our help desk has accessed their system and tried to, my lord, do their work and failed. Well, in 6.1, read with, my lord, kindly. In 10.3, my lord, we have, my lord, specifically, my lord, taken two stands. One, we have never been approached to do that, and second, it was not logically possible from our end to do that or to encounter the same problem, because had we, my lord, been able to do that, we would have, my lord, saved it, then, my lord, proceeded. And my lord, from the video recording which I have, my lord, submitted to your lordship, my lord, from that video recording, my lord, it would appear that they were when they were proceeding to fill up the form, my lord, they were not saving the form.
That's why they are not
Yes.
save the form. They are not.
And my lord, in my lord, my report, my lord, I have specifically, my lord, stated that there was
See, I have no
technical glitch.
problem to accept. Then I have to give the time to Mr. Datta to give the exception. Then the problem is the authority. If you're relying upon, I have no problem.
Same. They are
My
not
lord,
changing their stand. They are not changing
I
their
am, my
stand.
lord,
No.
But they are filing one thing. They are
That-
filing. If they're not changing, you will take it back. If they are
I am not appearing for them.
yes, you're not appearing. They are accepting this. If they wanted to rely upon this, then I have to give an opportunity to the other side. Simple thing.
Develop কিছু করছে হচ্ছে কি develop এখনো
But one more thing, my lord. In paragraph 7 of the original report, where they have, my lord, annexed a pen drive.
Hmm.
If your lordships open it, where that is at 1352. Please have a look to this one. This is what they have annexed. ওই যেটা ও pen drive pen drive যেটা kindly have a look to the time, my lord, at the bottom right hand side.
120 নাকি এগুলো লেখা ছিল 108
এই সরে গেছে
ওরে গেছে তো আবার
ঠিক আছে।
দিন আরেকবার
everything could have come to an end on the first day, but if they have accepted it online offline.
that doesn't permit so it's not in my hand.
No, this is very difficult. Now the online system and that through GEM portal, it is very difficult. This is, I think, 14, 15 case.
Yes.
and my lord, in the
Kindly see your right hand side bottom.
additional counter affidavit, my lord.
playing 1352 থেকে onward.
It starts from 1352 and ends at 1353. So it's a video. What is somewhere at the right hand side bottom, time and date.
স্যার এটা কি আমাদের ভিডিওটা
হ্যাঁ ওই যেটা pen
আমরা
drive.
প্রিন্টে দিচ্ছি তো
I think it's gone once again.
Okay, let us see.
So I'll be if lordship grants them further time to file any response to this, kindly record my if lordship kindly it's my prayer.
But my prayer is not kindly hear it
And,
without.
how soon you file? Because it,
Because I tell you lordship, dispute is now the entire dispute is between the admittedly between these 20. He is also a government. I am not in the
But I well,
the
ECL can, my lord, only, my lord, give us redressal by, my lord, accepting it offline.
by breaching my own tender terms. By breaching my own tender terms, can I do it? That the persons who are now
But they wanted to
will
settle.
come after me.
ECL wanted to settle. They are
You offer me how to resolve this dispute, not settle. And then they came up with the same offer that please take it in the physical form, which I
There
have
cannot
rejected.
be any other offer.
That is not a bona fide offer. I have rejected that twice. Before this court, lordship also told.
financial bid is open.
But bid
Financial is open.
but
No.
No,
it has been finalized. But we cannot declare it because lorships are already.
that is open.
It's that's okay.
Open.
So that I
Declared, not declared.
not declared. Not declared.
Well, give me, my lord, about কতদিন? Give me about 10 days time, my lord. No, because this is very technical. But
There is one problem that this is about coal. I'm not storing of coal. Problem is that I'm storing everything and
I appreciate.
there is a risk and danger.
and my lord, the judgment, my lord, relied upon by my learned senior friend, my lord, would show, my lord, there, my lord, the GM authority, my lord, specifically, my lord, admitted that there was a glitch, number one, and my lord, in that case, my lord, they have approached the
Actually,
head
the
of 2 days prior.
The Supreme Court, Honorable Supreme Court, Delhi High Court Division Bench, and
Yes, Delhi High Court
my
Division
judgment is also there.
Yes.
My lord,
If it is, I relied upon that.
Yes,
If it is found the fault on your part, then you will get an opportunity. If
Right.
it is found on the part of the tenderer, then it will be.
and in the, my lord, there is another judgment of Delhi High Court, my lord, where it has been recorded in respect of JAME, where my lord JAME has not denied, where JAME, my lord, has not, my lord, admitted that there was a glitch, my lord, court has said, my lord, Reed court cannot enter into, my lord, this disputed fact.
Respondent number 4 has filed additional or counter affidavit on behalf of counter affidavit to the exception filed by the petitioner. Counsel for the petitioner prays for time to file exception to the said counter affidavit. Let exception be filed by 12th of August 2026. List the matter on 14th August
My lord, 14th, kindly keep it with the next working day, my lord.
or 17th August.
Yes.
But but
17th August.
so is there Mr. Dotto knows the predicament of
As item number 2, as item number 2 under the urgent. Interim order is extended till the next.
For the 47.
17 with as item number 2.
Milord, my objection to this, Milord, if your lordship can extend it till 14th or 15th, because I will not be here during that.
17.
No, 17th it is returnable, Milord, my affidavit. May that be extended till 15th, Milord.
Extended till 15.
I'm grateful.
The interim order.
Yes.
Yes, switch 7.
Here for the respondent.
I'm for the rest.
My lord, I am for the yes. What is the prayer?
My lord, we have challenged the entire proceedings.
What proceedings, sir?
My lord, kindly comes to page number 25, the annexure where the,
Impugn order passed by the London additional magistrate.
my lord,
The chief judicial magistrate.
My lord.
Where is the order?
order is at page number 25, my lord.
Page
And
number 25.
25, my lord, and I have challenged the entire proceeding based on the notification which I placed before your lordship on the previous date, notification dated 10th April
Just a
2020.
minute. What is the order? The Genesis present answer.
Orders operating portion starts, your lordship, from at page number 27.
The appointment of special officer for taking possession. Section 14. Section 14.
Yes, my
Section 14, my lord.
Yes. So what is the difficulty?
My lord, I am relying upon the notification that these entire proceeding are not maintainable under the Surface I Act. This is the notification which I placed before your lordship, which says the last line says
In excess
that
of
the security interest
concern-
in secure debts of rupees 50 lakh and above, a financial institution for the purpose of the said act. Means, my lord, my loan amount was only 7 lakhs. My second submission before your lordship is, I am relying upon the judgments. Judgment do? Judgment to
Yes.
my lord, my lord, for the easy convenience of my lord, I have tagged it, my lord. My lord kindly comes to.
Yes.
May I read, my lord, the paragraph number 13? The learned single judge considered the facts of the case, that the submissions of the respective parties with regard to the maintainability of the writ petition. His lordship held that when a litigant had a statutory remedy available to him as an alternative or efficacious remedy for ventilating his grievances, a writ court could be slow to entertain writ petition. However, in the case in hand, the issue was not with regard to challenge of the action taken under the Surface Act as simpliciter, but the issue was with regard to the jurisdiction of the appellants to initiate the proceeding under the Surface Act. My lord, I am challenging that they do not have the jurisdiction on this ground. My lord, my lord kindly comes to page 8, paragraph number 15.
Yes.
Hence, we agree with the findings of the learned single judge that when the question of jurisdiction of the appellant number 1 to proceed under the Surface Act had been raised, the same being a pure question of law, the question of self-imposed restriction by writ court requiring
the borrowers to approach the DRT did not arise. Did not arise. Lack of subject matter to the jurisdiction went to the very root of the authority of the appellant number 1 to proceed under the Surface I Act. The allegations that the appellant number 1 acted in excess of jurisdiction under the law and in such situation an alternative and efficacious remedy would not be barred. The writ petition was filed again wrongfully in exercise of the power by the HFC. My lord, my respectful submission is that firstly, they do not have the jurisdiction.
Why?
The notification which I have placed, my lord,
What is the case? What is your case?
my lord, I am the borrower.
Ah.
I had
Borrowed the loan.
30th June 2016.
2016.
30th June 2016. My loan amount was, my lord, 5,13,911.
13,
13,
13 June 2016.
my lord.
And my lord, thereafter additional amount was granted in top of that,
Total-
2,33,000.
2 lakhs. So total amount is around 7,80,000 approximately.
First loan was
My lord, 5,13,911.
yes. And second upgrade when it was extended, loan amount was extended.
15 January 2017.
15 Jan 27.
2 lakh
Sec-
rupees.
2 lakhs rupees.
2,33,000, my lord.
2,33,000.
Yes.
My lord, so my total loan amount,
When the notice was issued, section 13 notice was issued to you.
Yes, my lord. 10th of
yes,
June.
10th of June 2024.
10th June 2024. Yes, then
And then
When-
possession notice 25/7.
when you given the reply, no reply,
My lord, the reply was
not there.
There was no any reply.
Possession was taken.
Possession is still not taken, my lord.
Symbolic possession not
Sim-
taken.
sim-
25th of
25th
September
of
2025.
September
5th
2025.
September 2025 symbolic possession.
Yes, my lord.
Then they have approached the magistrate
Then they approached the
for,
magistrate.
for receiver
My
for
lord.
taking possession. So
My lord.
now you challenge the magistrate's order.
I am not
You are
only
telling that-
I am not only challenging the magistrate's order, my lord. I am
That you are
challenging
challenging
the
the
entire proceedings.
Proceedings.
My lord,
Your
see the-
case is that in terms of the notification, you are not coming under the within the 50 lakhs rupees.
my lord, and the other notification which I will produce, RBI notification, my lord, that they are coming under the category of serial 54. This Aadhaar financing
Aadhaar Housing Finance Limited.
Limited is
Ah.
coming under the category of NBFC.
Huh?
It is coming under the category of non-banking financial company.
NBFC.
NBFC, my lord.
So you are NBFC.
This
correct.
Aadhaar banking finance is
You are NBFC.
they are NBFC. The respondents are NBFC.
That's why they are NBFC.
They are NBFC, my
Okay.
lord.
Then
So I am on the point that firstly they are the NBFC.
in NBFC, you are obtained the loan of 17,000.
I have respondents are NBFC. I have obtained the loan.
Respondents are NBFC. You have taken the loan of less than 20 lakhs.
My lord.
And now it has been enhanced to 50 lakhs. You are not coming under the notification. The sir, they
It has
cannot take the benefit of the surface.
Only my respectful submission, my lord, that it should. I am challenging that it shall not be proceeding under the surface.
Correct. Oh, I am
Correct.
telling.
That's the same.
Because of the notification.
Because of the notification and under the light of the judgment which I perused before your lordships.
Hmm.
The paragraph 13.
Paragraph
13 and 15 which I read before your lordship.
No, 13 and 15 with regard to the jurisdiction, the writ court jurisdiction.
Yes.
So what is your, how you are telling that how you are covered with this judgment?
Your Lordship may also see the para 33.
Thirty-two. 32 and 33, page 18. Yes.
So Lord, kindly take up RBC Acro. এখানে আছে দিয়ে। Yes. M1M4. One M. M4. Huh? 2-1. Then my lord M. Which defines the financial institution. Correct. Then my lord 4. I come under Roman 4. Any other institution? Yes, it must there. May I? Yes. Any other institution or non-banking financial company as defined under clause F of section 45I of the Reserve Bank of India, which the central government may by notification specify as financial institution for the purpose of this act. So my lord, from the statute, I am getting 3 things. That first is any other institution. Then my lord, NBFC in terms of 45I of the Reserve Bank of India. And my lord, central government will specify by notification the financial institution for the purpose of this act. Now, my lord, if your lordship kindly takes up the notification handed over by my learned friend. Kindly takes up 21. This is only modification of
21.
2020.
Yes, 21.
21.
21 था ना हमारे पास. 21. Yes. Maybe 20.
Or may I be allowed to read it? In act, but it was issued by Ministry of Finance. That my lord, it has to be in terms of M4. In exercise of the powers conferred by subclause 4 of M of subsection 1 of section 2 of Securitization of Financial Assets and Enforcement of Security Interest Act, the central government hereby makes the following amendment in the notification of Government of India. Ministry of Finance, Department of Financial Services, number so-and-so, dated 24th of 2020, published in the Gazette of India Extraordinary, section 3, dated so-and-so. In the said notification, rupees 50 lakh and above, the word rupees 20 lakh and above.
Yes.
So, my lord, it was modified to 50 lakh to 20. Now, my lord, now your lordship takes up the 2020 notification. What has got it? Yes. It was again issued by Ministry of Finance.
Yes.
May I?
Yes.
In exercise of powers conferred by subclause 4 of clause M of subsection 1 of section 2 of the Securitization and Reconstruction of Financial Assets and Enforcement Security Interest Act 2002, and in supersession of the notification of the Government of India, Ministry of Finance so-and-so, dated so-and-so, except as respect things done or omitted to be done before such supersession, the central government hereby specified
such non-banking financial companies as
defined.
as defined in clause A of section 45I of the Reserve Bank of India Act, so and so having assets worth rupees 100 crore and above. So, this notification was applicable only for the NBFC registered under 45I of the Reserve Bank of India. Now, my lord, if your lordship may I be allowed to hand up. After publication of notification of 2021, Central Government of India has published another notification, which is of dated 17th of June 2021.
Yes.
The earlier was of February 2021. This is of June 2021. Next, in exercise of the power conferred by subclause 4 of clause M of subsection 1 of section 2 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, and in supersession of the notification of the Government of India, Ministry of Finance, dated so and so, except as respecting done or omitted to be done before such supersession, the central government hereby specifies such housing financial company registered under subsection 5 of 29A of National Housing Bank Act in 1987 having assets worth rupees 100 crore and above as financial institution for the purpose of this. So, there are two notifications. One is for NBFC, another is for housing finance company, any other financial institution. Now, I come under
order.
a company registered under National Housing Bank Act.
National Housing Bank Act of the as like 2021.
Yes. If you lordship kindly see. Middle of the
এটা না না স্যার পেছি না এটা চ্যালেঞ্জ আছে
middle of the certificate, my lord. In exercise of power conferred on the National Housing Bank by section 29A of National Housing Bank Act, Other Housing Finance Limited, formerly known as EHFL, is hereby.
But how you file the how the retreat is maintainable before this court? How this this court is not having, because you have not challenged with regard to your challenge is surface. Your challenge is surface. How this court can entertain?
I am challenging, my lord, that this entire proceeding
Correct,
can
surface
correct.
proceeding.
My lord will
Just a minute.
my lord will kindly see the single bench order. Once my lord will see this.
I am not on that. You are practicing in High Court, Calcutta.
My lord.
You have considered my determination. See the determination. See my determination. You have a cause list. You challenge the proceedings of surface. See how this court.
He is relying upon the judgment passed by the honorable decision.
Even in the honorable single
decided is the point of law. Then, my lord,
Court has jurisdiction, but this court has writ petition is maintaining a different thing.
My lord.
You know, you are practicing in Calcutta High Court.
My lord.
If you are practicing in Calcutta High Court, we are having determination.
My lord. My lord.
Which group? Group 9.
Group 9, my lord.
Group 9 surface I.
It has to go.
Though the matter is heard at length, but this court find that this court is not having the determination accordingly. Matter is released from the list of the court, this court, with the liberty to the parties to mention before the approved court having determination.
Court number 7.
Not so hard. That they will. No, I am not on that.
My lord is on the determination of surfacing, specific determination.
Specific determination. Now, initially I was taking because I was thinking on that judgment of the division, but subsequently my court officer has reminded me. Yes.
May I take your leave?
Item number 8.
Item number 9, my lord, I am happy on.
Eight.
9 is a
Eight.
different matter.
8.
Eight.
Item number 8, your lordship.
Why tag will say?
Item number 8, your lordship. What has happened is there has
I
been
8 is tagged with 9? By which order? Okay.
don't think it ought to have been tagged, your lordship. Completely independent matters.
Yes, who is partying? You are appealing for?
We have served. Standard Chartered Bank is respondent number 3. They are the principal defendants against respondents against whom we are asking for the relief, your lordship. My case is very simple. There was a unilateral freezing. Now, admittedly, that unilateral freezing of the bank account was only pursuant to a cyber cell complaint notification, not pursuant to any judicial magistrate's order. They admit that. Your lordship will kindly take page 85.
Yes, who is appearing for the bank? Where is the report?
My lord, according to my lord, kindly take page number 85, my lord.
Ah.
My lord, when it is structured the cyber can keep the account.
All account.
Kindly
Have you gone through the SOP of the latest April SOP?
yes,
Gone through? Show me. Madam, the court is asking one thing. Have you gone through the latest SOP issued by the government with regard to the cybercrime fraud on? So how you can freeze the total account? Lien account. You can lien with regard to the what is the disputed amount?
10 lakhs.
So you can lien the 10 lakh. Why the total account?
If the direction we are ready to
Where you give the report, let your officer give something in sign and signature.
not.
Every time you are taking the same plea, and tomorrow you will go to the appellate court. No, you have not submitted any report. Court has passed an order. You act according to the instruction on return. But I find here today you are appearing, tomorrow the another will prepare an appeal making any allegation the bank has not given instruction. That's why I stress upon the written instruction of each and either bank or the department.
And I'm also referring to your lordship's judgment.
No, latest judgment also. The petitioner has filed the present date application praying for a direction upon the respondent authorities for defreezing the account of the petitioner. The concept for the petition submitted the petitioners the bank has freezed the account of the petitioner only on receipt of the complaint from the cyber crime station.
Yes.
Cyber crime police station. Police stop. Learned counsel for the bank submit that the bank has acted upon the report received from the cyber crime police station. Accordingly, the account of the petitioner has been freezed. In view of the above, the bank is directed to submit the report with regard to the submit the report to stating that how the account of the petitioner has been freezed, what is the disputed amount, and what is the total account lying in the account of the petitioner. Let the report be filed by 12th of August, release the matter on 13th. Under the same meeting within 10 minutes.
May it have some precedence. I know.
Within 10 minutes.
I'm deeply obliged.
Yes, what is the 9?
Item number 9, my lord, I am appearing on behalf of the petitioner. Petitioner participated in the tender process for installation of solar submersible pump, my lord. And work order was issued. Service to work order was issued, my lord. And my lord,
work order?
Yes,
Which
my lord.
department?
This is, my lord, Panchayat Pradhan
So
floated
go to the
tender.
panchayat. This court is not having
No,
determination.
no, my lord, residuary matter, we can file the tender process, my lord.
Go to the panchayat. if you-
Monetary claim, no. my
Yeah?
lord, Pradhan has issued the tender,
Go to
NIT.
the panchayat. Go to the panchayat. Go to the
Okay.
panchayat court.
My lord.
The petitioner has filed the present date application challenging the tender process issued by the panchayat authority. Thus, this court is not having determination. The matter is released. With the liberty to the petitioner
My
to
lord.
mention the matter before the appropriate court having determination. Next.
ঠিক আছে না?
Your Lordship, a slightly curious case. Slightly curious case. What has happened here is there was a MSME proceeding which was going on. Now, in that, the agreements upon which the MSME claim was lodged was of around 2017, and the claimant had got its MSME registration in 2019. So the MSME council took a pretty simple objection that if you are not registered prior to the agreements and your transactions, you cannot come before the facilitation council. Now, what has actually happened, however, is the
Who is
Supreme
for the
Court.
respondent? Have you
We
served?
yes. So
Which department? Which bank?
no, no.
Ah. Facilitation Council, Bangar Small Enterprises. Yes,
May I proceed?
nobody
So-
is appearing.
Yes.
Yes.
So what has actually happened is now the Supreme Court on 10th of January 2025 came out with an order saying no, filing an application before the MSME board has nothing to do with your registration with MSME and all that. You can do it even if your registration is afterwards. Now, it also held that earlier judgments which had opined on as an obiter that this cannot be done.
No, that is full bench has decided now.
No, that is exactly the problem. They said that please go. We are still, however, just to clarify, we are referring to a third bench. Now, what the MSME, your lordship will come to page 44. I presented this judgment to the MSME, and what they say, your lordship sees the last portion, decision of the council.
Page
44.
44 page.
Bottom, decision of the council.
Yes, decision of the council.
Yes. Members opine that in the judgment dated so and so, the Honorable Supreme Court of India expressed their opinion about various earlier decisions regarding the preconditions of MSME registration for filing a claim before the MSME Council. And for further clarity on this point, they note this also, referred the matter to the larger bench. Members further opine that the said judgment would be sent to the appropriate authority for further clarification, as the council is unable to construe any final stand from this judgment. They themselves are saying they cannot do this. It was unanimously decided that the matter would be kept pending till clarification. Now, what is now happening is this, your lordship. First, they say they will send it to some authority. Now, there is no authority because they are acting as the arbitrator. Right? They cannot send it to anybody else.
Correct.
One. Second thing is that you cannot sit on it. You have to, whatever is there, you can decide on the earlier course of judgments, or you take note of this judgment and decide the point. Now, what has happened is this was decided, if your lordship sees the date, 3 days after the Supreme Court judgment. This decision order is of 13th January 2025. We are in the middle of 2026. 18 months have gone. And we are still stuck. No hearing is being done. Nothing is being done. So, and the Supreme Court has not even constituted the bench. At least there is no hearing at least of that. So what is now we are stuck in a situation is that till the Supreme Court ever hears it, it may choose never to hear it at least for 5 years. And my claim has been lodged in 2020. My claim is of 2020. It is already 6 years in the MSME Council. My innocuous prayer was your lordship will give directions.
So what is
today.
the prayer?
Yes, your lordship will
This
see.
code is not in 141, 142.
No, no, I'm not on 141, 142. I am only to set aside this direction that they will sit till it decides and gives a direction to the court, to the MSME council to finish with whatever on record, whatever judgments they are, gives a decision either way. Then I can proceed further. Because otherwise, till the Supreme Court ever decides or something, as per this order, I will be stuck. Because they will not do anything. And there are, now your lordship, lots of Delhi High Court judgments also, which say that the new judge, that NDCC is what is going to be followed, because it has categorically said why it is the Shilpi industries and all are wrong law.
So what the Supreme Court has held?
Your lordship will see. Page 85. Page 85.
On the interpretation of the provisions.
On the interpretation of the provisions of the Act, we have arrived at a clear opinion and have expressed the same, that you do not require registration. That was what they had held. Though it is possible for us to follow the precedents referred in paragraph 27 to arrive at a conclusion that the judgments in the case of Shilpi Industries and Makali Foods, coupled with the subsequent orders in Vaishno Industries and Nitish Estates, cannot be considered to be binding precedents. On the issue that has arisen for the consideration, taking into account the compelling need to ensure clarity and certainty about the applicable precedents on the subject, we deem it appropriate to refer this to a 3-judge bench. And registry is directed to this. So they have held the position, what the law which has been held by them is that there is no requirement of registration prior to the agreements which are being disputed. And thereafter they say also, as it said in paragraph 29 itself, that all those Supreme Court judgments which say otherwise, they are also not good law. We can argue, but for clarity, they have given it to a 3-judge bench. Now there are, I can understand your lordship, there are 2 sets of judgments now. One is the Shilpi Industries on which this is discussed, and one is this one. Now there are also judgments.
What is the prayer?
Your lordship will come. My prayer is only to set aside that order, last order.
The members have appointed the judgment date for January to 10th January 2025. The Honorable Supreme
Page 11, paragraph 8.
for the various earlier directives
Query.
regarding preconditions. Decision of finding of review. So how this court can? Either you go to the Supreme Court, because see, the Supreme Court last judgment is this one.
No, I am not on that, your lordship. I am not saying hold which law. I am not saying that law. I am saying this is the order which has been passed.
So what they will do?
Your lordship, there are specific judgments which say when there are 2 judgments of the same court, which one to follow, or they can follow either one.
That's correct. But here the question is that matter before the Honorable Supreme Court, and Honorable Supreme Court referred. If today they will pass an order, okay, refer to the
Your lordship, this is being done.
Facilitation Council. If the Facilitation Council, whether they can do.
Your lordship,
as per the
every
judgment,
high court
pending.
is. Your lordship, may I just indicate? Every high court is deciding these matters. High courts are also deciding on the same point.
Correct.
After the NVCC judgment also, there also the same question will arise.
Correct.
So they are being done. So your lordship, with all due respect, if a matter has been referred and the matter is pending, that does not mean that there will be a judicial vacuum during that period. If the 5 years they don't decide it, that means all matters which are in MSME council.
Correct. So that's why you see if today the chairman pass an order referring the matter to the arbitration.
But arbitration, this is already arbitration has commenced.
Correct. If you pass an order.
Yes.
What would the effect?
There will be no effect, your lordship. No,
If-
in the sense that matter will proceed.
Matter will proceed, but
Your-
what would be the effect once the Supreme Court has referred the matter to the full bench, whether it should be arbitrator or facilitation
May I
council?
just indicate this? Whether it is the arbitrator or whether it's a facilitating council or whether it's a high court or whether it's any court, it makes no difference, Your Lordship. My
Why?
submission would makes no difference. The reason is, when as of now there is no law. As of now, law which has not been laid down by the Supreme Court in a 3-judge bench. But the Supreme Court has laid down something here. And it has also laid down in Shilpi Industries.
Hmm.
There is an entire line of jurisprudence
Hmm.
which says that if there are two set of conflicting judgments, how you choose and which one you choose.
If the matter is not referred to full bench,
No, Your
if the
Lordship.
matter is referred to full bench, how we can say now you
Your
go and
Lordship, there are-
you go and adopt the second
Your
second.
Lordship, then by that, if that was the way, then what would happen is, any time a matter of law is referred to a larger bench, the entire country will come to a standstill with regard to that law. Will they, Your Lordship, because let's say, I will give you a clear example. Your Lordship, that in-race matter with regard to stamp registration and insufficient stamp in section 11 matters. It was sent to a higher bench 3 times. But that doesn't mean that the entire country did not, or the high courts did not entertain a section 11 during that period. All I'm saying is that they will rely upon they are also a quasi-judicial body. They will rely upon the judicial precedents which say, when there are 2 sets of judgments, even if one is pending before a larger bench, what is the law, they can choose and they can give an order. My thing is, Your Lordship, for 1.5 years already, there is nothing is there. This matter is pending for 6 years on the same point. If the Supreme Court does not decide in 3 years, my matter will go on be pending. Whereas all other high courts, they are deciding this point. They are also subordinate to the Supreme Court. I can, if Your Lordship wants, I can bring this Delhi High Court. I don't have them right now, the Delhi High Court judgments. I didn't think that was the question that would come up. But because other courts are deciding on this point. There are judgments on this point. Bombay High Court is taking some different view. Delhi High Court.
Because why I'm telling, this court has passed an order staying the order passed by the authority for referring the matter to the chair, to the arbitration. Due to that's why I'm telling. So this court cannot pass a contradictory order. That's why I'm telling, if suppose the arbitration proceeding is going on and the arbitrator pass an order, in what would be effect of that?
Your Lordship, may I just see? That would be effect at a later date, but that would not mean that as I am again in submitting, Your Lordship, the country can go on
And pending this issue, can the authority or MSME facilitation can refer the matter to the arbitration?
Your Lordship, Your Lordship, again, there are 2 sets of judgments.
I appreciate your argument. I appreciate there are 2 sets of judgment. The court has to see with regard to the
And till there is a 3-judge bench. Till there is a 3-judge bench, decision actually comes in.
Which is the later judgment we have to follow.
Now let's take a different example. I'm taking a different example. A matter goes from here, from a high court to an appeal.
You come with the judgment of the Delhi High Court. We'll see to that.
When tomorrow, day after, Your Lordship keeps it day after.
As per the prayer made by the counsel for the petition, the case adjourned. Let the matter appear on 7th. Next.
We have for the back. My application. There was a point of maintainability.
Yes, what is the point of maintainability?
I'll just briefly address my lord, if senior friend can then continue. My
Yes.
lord, there is one alternative remedy in view of the amendment of the insolvency and the bankruptcy code, my lord. Disciplinary proceedings, now the NCLAT has the power, my lord, to adjudicate.
Yes. If the final order is passed.
This 6th April 2026, my lord, will kindly come to internal page 30.
Hello, this is an amendment of, it starts from 30, amendment of section 220.
Page 30.
Yes, my lord, internal page, it's on the left hand, right hand corner.
Yes.
My lord, in section 220 of the Principal Act,
Where we are reading?
my lord, 66,
66, yes.
last end.
Yes.
In section 220 of the Principal Act, for subsection 1, the following subsections shall be substituted, namely, the board shall, my lord, I will just draw your attention to the relevant, it's at page 31, my lord, subsection 7, just over on the next page, 7. It
Yes.
starts with F. Any
Yes.
person aggrieved by an order of the disciplinary committee under subsection 2 to 5 may prefer an appeal to the National Company Law Appellate Tribunal within a period of 30 days from the date of receipt of the order. My lord, this is one point. Second point, what we were urging is, my lord, since the IBPI, which has passed the disciplinary proceedings, that is based out of Delhi, and the records are in Delhi. So that is why the Honorable Delhi High Court will have jurisdiction. I am for the bank, the complainant out here, my lord, but I thought we'll just indicate this before my lord. I'll just make detailed submissions on this.
Now, my lord, regarding second point, IDBI has the office at Delhi, but the Honorable Delhi High Court on this aspect delivered a judgment. I am giving that judgment. Exactly on the same issue. উল্টোপাল্টা করলো কি? আলাদা গুছিয়ে রাখলাম। কারণ এটা দিও না, এটা দাগ মারা আছে। পেয়েছি। Yes. নিচে একটা কপি আছে। আচ্ছা আচ্ছা আচ্ছা, আলাদা করে রাখা ছিল এখানে, 3টে কপি এক্সট্রা রাখা ছিল। আচ্ছা আচ্ছা, দেখো, আচ্ছা, এটা না। Now, my lord, here your lordship kindly see, the point was taken. The petitioner filed the writ petition before. Your lordship kindly see paragraph 2. Paragraph 2. The fact of this case would include indicate that the petitioner is a chartered accountant and a registered insolvency professional with the Insolvency and Bankruptcy Board of India since 2017. The corporate insolvency resolution of Jemas Engineering Limited was admitted by the National Company Law Tribunal, Kolkata bench on 30th April 2024. Mr. Arun Kumar Gupta was initially appointed as the interim resolution professional. On 18/7/2024, petitioner was appointed as a resolution professional by the Committee of Creditors and managed CIRP. The CIRP concluded with an order for liquidation on 17/12/2024. A liquidator was appointed. All relevant documents, records handed over to the liquidator in December 2024, January 2025. The petitioner opened, etc. I am skipping this. Then, last 3 lines, a complaint was filed by the former IRP alleging unauthorized operation of CIRP bank account. Based on this, IBI issued a show cause notice on 10/9/2025, and the disciplinary committee suspended the petitioner's registration for 2 years on 26/2026. The petitioner residing in Kolkata, State of West Bengal, is a registered insolvency professional engaged in professional assignment, COC proceeding, and other related activities, primarily in Kolkata. The respondent situated in Delhi, and the impugned show cause notice dated 10/9/2025 and the suspension order dated 26/2/2026 was issued from the office of Delhi. The sole basis for invoking this jurisdiction of this court appears to be the citus of the issuance of the impugned orders. However, this alone would not ipso facto confer jurisdiction under Article 226 of the Constitution of India. Learned counsel for the petitioner submits that the authority which has issued the show cause notice is situated in Delhi. The impugned order has been passed in Delhi, the petitioner does not have any relation with NCLT proceeding, which according to him are independent and are distinct from the one which are sought to be carried out against the petitioner. He also submits that since the cause of action has arisen within the jurisdiction of this court, therefore the petitioner has right to approach of this court. Having heard the learned counsel for the parties, petitioner, the court finds that a part of cause of action has arisen within the jurisdiction of this court. However, Supreme Court in case of Kusum ignores and Alliance Limited versus Union of India and others held that even if a small part of cause of action arises within the territorial jurisdiction of the High Court, same by itself may not be considered to be determinative factor compelling the High Court to decide the matter on merit. In appropriate cases, the court may refuse to exercise its discretionary jurisdiction by invoking the doctrine of forum convenience, etc. Now, there are certain decisions have been indicated. Then, after that, the court has come to the findings in
Part cause of action.
paragraph 11. In fact, in the instant case, there may be a part of cause of action has arisen in Delhi. However, the same should not be the sole reason to entertain the writ petition. And it has been transferred to Calcutta.
My lord, I must
Now, my lord, here, the entire thing happened in Calcutta, and only thing, the office of the principal respondent number 1 is in Delhi. So it cannot go to the Delhi High Court. That is the judgment of Delhi High Court.
Yes.
So, my lord, after this judgment, the issue has been decided, there cannot be any further question. Secondly, if your lordship kindly have a glance to the notice tag, page 30.
Yes.
Amendment of section 220.
Appeal provision has been included.
Yes.
Any person aggrieved by the order of disciplinary committee.
Order. No order has been passed. No finding.
What is the challenge here?
Nothing. Your lordship kindly come straight away the website publication.
What you have read for?
Page 102. This is the publication.
102.
102. Only this has been published in the website. AFA suspended. No reason, nothing. Section 220 of section 220 of the Act clearly indicates that opportunity of hearing in the show cause has to be given. That has not been done. What my learned friend is saying, if it is not been done, it ipso facto is bad in law.
Yes. Yes, any
I am
order?
not the complainant, my lord. I am for the bank, the authority. I was just assisting, my lord, as far as the alternative remedy.
Who is for the bank?
I am for
Eh,
the bank.
Yeah, who
I
is for
did
the
that.
authority?
My lord, respondent number 1, that's the insolvency.
Who is appearing? Insolvency?
Maybe I am not concerned with him.
The main is the IBI.
We have already served. On the date itself, he has received it. And subsequently we got this.
Have you not received any reason order?
No.
Only this.
And most surprisingly, the show cause notice issued, I have given answer to the show cause notice. Elaborate answer and short answer. And I have informed to the NCLT that this is the show cause. This is my designation tendered. And moreover, you will also kindly see, the most important, interesting thing is this, the
Where
State Bank.
Where is he was working? Calcutta?
Calcutta. And in the State Bank, you will also kindly come to page 33.
Yes.
I tendered my resignation as my appointing authority is NCLT on the basis of the order. So it has gone to the NCLT. And before the NCLT, this is the order. Since the replacement of liquidator has been sought by
Page.
Page 33.
Since the replacement of liquidator has been sought for an appropriate application, see Soumitra Lahiri and Mr. Vajendra Kara Sharma to replace the as liquidator.
No, not this. Your Lordship kindly come to, I'm sorry, this is not. Your Lordship kindly come to next order.
He was appointed liquidator in the Calcutta NCLT.
Yes.
My lord, only thing is, my lord, just my instruction said that the matter has been reserved. I think final order, that's my instruction. Although I'm just assisting, my lord, because I'm the complainant.
Page 49. Huh? Your Lordship kindly come to page 49. I'm sorry.
All of the so-called notice to appropriate indicated.
After this, my lord, what remains, I don't know. And on the basis of that, the learned NCLT has passed an order. This is the order, final order. Page, 1 minute, my lord. Yes, page 93, starts from page 93.
So you have been allowed to withdraw.
Yes. But tender my resignation,
Where is that order?
Yes.
Page 94, my lord, is 90. That order is there. And
Yes,
paragraph 17 at page 97, I think my lord, senior friend.
Paragraph 17.
Yes, my lord, at page 97.
Yeah. But when the State Bank has submitted, they will not withdraw the complaint before the IBI, but will unconditionally withdraw the so-called notice issued upon the liquidator. So what? So you will not unconditionally withdraw the so-called notice?
No, I have been replaced. This is.
No, 17. But that SCC of the Mangalam Physical Services Private
No,
Limited, though
maybe, but this they will say that before so-called they will withdraw. And that has been done by the that has been said by before NCLT by the State Bank also.
Correct.
Complaint service, that is.
Complaint service. If the complaint service and you are withdrawing the so-called notice, what purpose?
It is by the IBBS. That is what my lord.
To whom you have made the complaint?
To IBBS.
So if you have made the complaint to the IDBI, so the IBBI has to inquire into the matter. If it inquire into the matter, the so-cause is required. If the so-cause, unless and until so-cause is not required, the inquiry cannot be made. If you withdraw the so-cause, you continue with the complaint. How the IBBI will continue with the complaint?
My lord, let IBBI be present, my lord. I think one date notice get it up. And my
You
lord,
logically give me stay order.
and my lord, just
I am
one
suffering.
and one more thing, my lord, my learned senior friend was relying upon a judgment, my lord, that is under appeal before the Honorable Delhi High Court, because that was on the basis of forum convenience.
No, that correct. That not forum convenience. Where he was working.
No, he was based out of Kolkata, but the authorities
maybe out of Kolkata, where the cause of action was. He was working here. He was appointed a liquidator here. There is an allegation against this petitioner because while he was a liquidator, he has done some mischief with the as a liquidator. Then he has withdrawn. He filed. Then you have made a complaint where in Calcutta NCLT. Then part cause of action. But where is the
IBBI present because they
correct, but they are not appearing. What this affidavit of service is there? You do one thing. You again you serve the notice. Come on Friday. If they will not appear in the second notice, I will pass appropriate order.
Friday, my lord, this will not reach to them because it is in Delhi. If I send it by speed post, it
Send
will
by mail. Send by mail. Send by mail.
Mail. Very well.
The petitioner has filed the affidavit of service. Let the same be kept with the record. In spite of the service, none appears on behalf of the respondent number 1. This court find that one opportunity is to be given to the respondent number 1 to appear in the matter. The petition directed to inform the next date of hearing to the respondent number 1 through mail. Lead the matter on 7th of August 2026. It is made clear that in spite of receipt of the information about the next date of hearing, if none appears on behalf of the respondent number 1,
come appropriate order, the matter will be taken up for hearing in the absence of the respondent number one.
Come on, may I pray only one thing?
Yes.
Till your lordship fix the matter on 7th.
Let first we see, you are appearing for 5 because who has issued the suspension order? Then we have to see where this with. Okay, I will allow. I am not. Let the respondent number one come first. He has to give the answer because once he has received, withdraw the so-cause notice. So how we can proceed the complaint? If it's not in a position to proceed with the complaint, how the suspension is been issued? And this is not the way to suspension.
And moreover, it has.
But whose complaint? And they have no objection for withdrawal of the so-cause. The person who has made a complaint, he is telling, no, I will continue with my complaint. But no, so-cause cannot be issued. Yes.
And moreover, your lordship can see, if I take your lordship to the paragraph of the petition, when the he has been asked to removed by the State Bank, it is been put to vote. No one casting any vote.
Let
No obligation. Nothing.
Inform both of you.
Till 9th, my lord, a short interim order cannot be passed.
Nothing
For
will
saving
happen.
my face only. Only for saving my
2
face.
days, Friday. That's why I kept on Friday. I have not kept a long day. Friday come within 5 minutes, it will be there. Yes. Yes, who is for the item number 12?
এই তোমাকে এটা দিস তোমার এটা রাখবো ভাই এই তোমার ফ্রেশ কপি দাও এই ডার্ক ওয়ান কপি দিও না
Who is appearing?
I appear. Thank you.
Petitioner?
Yes.
Yes. What you filed? Sustaining barring the learned Wakaf tribunal from proceeding with the title suit.
Lordship.
How the writ court?
Your Lordship, ordinarily it is filed under 227, Your Lordship, but the my lord's jurisdiction, there is no absolute bar, my lord.
Go. Challenging the draft.
May I just briefly state, my lord, what has happened? My lord, a person, my lord, claiming to be a mutawali has instituted a suit before the learned Wakaf tribunal, claiming certain portions of land to be as the Wakaf land. Now, my lord, we have challenged that action, my lord. Lord, interim injunction order was granted in his favor. We have given, my lord, our written objection, and we have also filed our order 7 rule 11. Now, my lord, rule 11, my lord, dismissal of the plaint. Now, my lord, the tribunal, without adhering to, my lord, the procedure regulation, your lordship, is keen on, my lord, hearing the interim injunction first. Lord, we say this person who has claimed to be the mutawali is not a mutawali at all. He was appointed in the year 2014 for 5 years. On the date of institution, he was no one. So there's a challenge to the locus standi, number 1. Number 2, your lordship, under the plots that has been claimed as, my lord, Wakaf land, your lordship, there are several owners who own the plot. My lord, if my lord kindly sees, my lord, there are 2 plots, 609,
Whatever it may
605.
be, your prayer is against the order of the Wakaf tribunal.
Lordship.
If you are challenging the
My lord,
Wakaf tribunal,
it's not really, my lord.
6,
My lord, it is
227.
It's not really, my lord, there is no order, my lord, on date against which I'm filing this, my lord. It is altogether, my lord, the way it has been proceeding, my lord.
Maybe.
Lord, this is manifestly arbitrary, your lordship.
226 not a superintending power. Superintending power is under the 227.
My lord, if
revisional
my
court.
lord, I can show, my lord, subject to correction, your lordship. If I can show, my lord, there's manifest arbitrariness in that action, your lordship, then perhaps
Maybe.
my lord will indulge, my lord.
Maybe,
into-
but go out there. You have the other court, you go to the 227, file a 227.
My lord, in that even, my lord, may I pray for something? My lord, lock, stock, barrel, my lord, if my lord can transfer this matter because it's pending
How
for
it
law.
can be? WPA to 226, 227 can't be. Now, earlier the court used to. Now it is totally.
Lord, in that even, my lord, may I try to, my lord, impress upon your lordship my points, my lord.
Yes, you can.
I am telling, but I will not hear. What impress? Your prayer itself is there, then I cannot.
Lord, may I
I am
first?
giving a liberty to take the liberty to file the appropriate before the court.
My lord, kindly passes it over. Let us take the instruction, your lordship.
Take instruction.
Let us, my lord, come back at 1, your lordship.
Also.
My lord, in item number 13, I am appearing on behalf of the respondent bank. My lord, yesterday I have been served with this, my lord. My lord, I am paying for short time at times, my lord, because I have been served with this affidavit yesterday after 7:30.
I was supposed to file a report. I was supposed to file an exception. My exception is purely on the point of law,
Purely, my lord,
on
so
his
many
documents.
annexures, so many annexures, so many documents have been annexed. here.
Bank statements only. But
So many documents, I have to take instructions.
but if he so pleases, I will not show any of them. I will not show any of those annexations. He has relied upon a master direction. I will rely upon only that my bank account has been frozen without any notice given by any agency. My bank, it's a current account. My business has completely come to a standstill. And they have done so without writing any letter. On the last occasion, he orally made submissions which are contrary to the report. But I don't want to press that. I'm only saying my lordship allows me to file this exception.
Yes, what do you want?
My lord, if possible, my lord, I will only be for a
For?
this week.
For?
Because I have received this yesterday evening, my lord. Some new documents are there.
So what is the prayer?
My prayer is to defreeze my account. That's all.
Freezing of account, what is?
No, my lord, this is not a case of cyber fraud. It is a case of money mule.
Yes, you submitted
Yes,
that. I
that's
recorded
what
all
is
this, your
submitted. So
submission.
it's a I have my.
You got this is not a cyber fraud.
It is not a case of cyber fraud. It is a case of money mule.
Money?
Money mule.
Mule, yes.
Mule. Which is one of
So how soon you will come?
Subject to my lord, if it is next.
I leave it to your lordship.
Subject to.
The petitioner has filed exception to the report filed by the respondent bank. Let the same be continued. Respondent bank prays for time to go through the exception filed by the petitioner. According cases adjourned, let the matter appear on 11th.
11th. My lord, that last bit.
Within 10 minutes.
I'm most grateful. My application.
All matters is having the precedence. Yes.
My lord, I
Which
discovered
for the Union of India.
ROC.
Lord, I am the affected party.
You're the
So
affected.
I am the affected party. I have been removed. But the ROCs who I have claimed, my lord, yesterday also they did not appear. May I only say this? My lord, would it be your lordship pleasure, Mr. Before I have said it, Mr. Chaudhary wants to say no.
Yes.
Lord, could I give another notice to ROC?
Not necessary.
And come back next.
Not necessary.
Yesterday there was an
But
urgency
this is-
case ground. I want the ROC to be here.
Lord, according to me, Lord, ROC has nothing to say in this matter.
Very well. Then, my lord,
Please
may I just, no. I have impleted the ROC. The writ is against the ROC. I am saying infraction of certain provisions of by the ROC. I want my writ to move. The private respondent can't coerce me to move it.
ROC.
I mean, twice we've served notice. They've not appeared. I'll serve once and come back next week.
They will never come because they are not concerned. He was a director in my company.
Let him not hijack.
Okay, Mr. Chaudhary.
Yes.
Let one notice.
Let
be given.
ROC
If they
come.
will
Another
not-
notice we come and then I'll
one
bring
notice
them.
they given. If they will not come,
Then I'll do it.
record
And,
it. I will
that,
record
please
it.
does that. That's all. I don't want it to be heard without the ROC. That
Affidavit service filed by the petitioner be kept in the record. In spite of service of notice, none appears on behalf of the ROC. The petition is directed to again inform the date to the ROC. It is made clear that on the date fixed, if in spite of having the knowledge of the date, if the ROC will not appear, the matter will be taken up for hearing in the absence of the ROC. This is the matter on 13th
Never
August.
rely on
13th.
30.
Lord, one request, Lord, 19th.
18th onwards.
18th.
Or 18th onwards, any day as per my lord's
Onwards.
convenience.
Okay, 19 kar dijiye. 19 within 10
That's
minutes.
2 weeks. Very well. I mean, nahi majkhana chali.
He is telling that he is the victim. That's why let he ask.
Come back on the night.
For the petitioner. This is my affidavit of service, my lord. I have served twice.
On behalf of the private respondent, December 30 to 21.
Yes, my lord.
For 1 day accommodation. Because my lord,
Obey.
I have
All
received
matters, accommodation, none.
only 1 day, my lord. I haven't got the chance to read it.
My lord, my prayer is very simple. Let me first, my lord, place my case.
My lord,
Then if time required, my lord,
to submit, my lord.
What is the matter?
my lord, matter is that in the, my lord, village area, there is the forest lands. So for the forest land, state of West Bengal come up with a committee, forest protection committee.
Correct.
In the forest protection committee, certain local inhabitants had been incorporated in the committee.
Correct.
Our grievances is that our predecessor interests were in the
In the committee.
Subsequently, they passed away. According to their notification, we should be incorporated in that committee if we discharge our duty for past 5 years to look after the forest. Our case is that since 2014, we are looking after the forest, but neither no issue facts of the forest is given to us, nor
Is the forest department.
Yes,
How
my lord, I
this
have
court?
annexed the notification.
No, how this court? Forest department is
Forest,
having the.
because my lord, I am not challenging the, my lord, taking of land to the forest. All I am saying, because I can't go, my lord, group 1.
Okay.
Because it is not, my lord, within the periphery of lands matter, because I am not challenging the acquisition or acceptance of land, taken land by the forest department. My group 9 as because, my lord, my prayer is restricted to that. I wrote a representation to the DFO, who is actually a authority, that you consider my representation that we should be enlisted in the beneficiary list. Because, my lord, I can't also go for service matter as well. Because this is not a service.
Okay.
Perhaps, my lord, subject to my understanding.
My lord, may I submit, my lord? It is about hijacking of fund, my lord. It is we are who are the looking and who have formed the committee as per the government of West Bengal. But I haven't got the because, my lord, I haven't got the chance to read what I am submitting.
Okay. Go when you come?
Tomorrow, my lord. Tomorrow.
Not today.
Affidavit
service kept in the report?
My lord, twice, my lord. My lord, before election and after election, my lord, I have served.
After কালকে দিন আমি record করে দেব.
My lord, retain its position, my lord.
I will also take some instruction.
Yes, come with the instruction.
Unlike.
Yes, next.
My lord,
12th May. Now till date you have not filed the reply. April there is a direct. What is the matter? How before this court? Upper primary school teacher? Maybe. How this court? Affidavit is not completed. Filed.
Our opposition has been filed. On the last occasion, we have filed the
Affidavit is not, well, matter is not ready for hearing. How this court can take up the matter? This court is not having the determination to hear the matter. According matter is released from the list of this court with the liberty to the parties to mention before the appellate court having determination. Next.
17, my lord, I appear for the petitioner, my lord. I'm led by Mr. Vikas Ranjan Bhattacharya in this matter, my lord. Due to some
17.
Yes, my lord.
17 was a case wherein during election, the LIC officers were given duty as a presiding officer and other duties. Election Commission had issued a notification that during this period, their performance would not be graded because LIC has a policy, if they do not fulfill the required benchmark, they will be prosecuted or action would be taken. Accordingly, during pendency of the matter, we had filed it, and that is part of the supplementary affidavit filed by them.
Despite that order, my lord,
The
LIC is terminating, my lord, the employee.
Who is LIC? Issue notice.
My lord.
They will not appear, then I will pass out. They filed affidavit.
They filed an
Yeah, your lordship, they had filed an
They
affidavit.
filed affidavit.
They filed.
Who had appeared? Who is the advocate on
Learned
record?
counsel from Bar Library is appearing.
Arindam Sheth.
My lord, I am for the petitioner.
Last
Reply.
notice for LIC.
Affidavit in opposition, respond number 5 and 6.
5 and 6.
5 and 6, Mr. Asar Chaudhary. Inform that. As none appears on behalf of the,
Your lordship, kindly just make it not today so that it can appear
yes,
tomorrow and
yes.
can be disposed of.
you can bring
Yes,
that.
I'll inform. I'll also
Today.
inform. Much obliged.
Next. Yes.
We have taken instruction, my lord. But let us proceed, my lord, if my lord, on the maintainability ground, my lord is willing to dismiss, but my lord, let us proceed, my lord.
Proceed. Okay, proceed, no problem. If this court is not having a determination, how you are telling the court to proceed with the matter?
Lord, kindly sees, my lord, we have not challenged any particular order, your lordship. We have challenged the entire action in which, the way in which the court is, the tribunal, the learned tribunal is proceeding. My lord, may I just take my lord through the factual aspect? My lord, the plots in question are plot number 609 and 605. Lord, there are several, my lord, subplots inside the plot. My lord, kindly takes your lordship page number 84.
Yes.
Written in Bengali, your lordship, if my lord kindly.
I cannot read.
Copy.
Cannot read. What is the suit before the tribunal?
May I just take my lord through the suit, your lordship?
What
My
is-
lord will
what is
find
the
the
suit?
plaint at page 31.
What is the suit?
But
Page
it's a
31.
declaration. My lord, kindly sees the prayer in the suit, your lordship. 31 is starting, my lord, the suit. Kindly sees. Nazrul M. Hassan is the plaintiff. Pradeep Kumar Pradhan, then Nondita Pradhan is the petitioner. My lord, herein and defendant there.
Code of backup. Where is the prayer?
Lordship kindly comes to page 35. Then 36 is the prayer A.
Draw a decree declaring the discap schedule land of property. Regional work of estate and road EC number. Yes.
Kindly sees, my lord, prayer C.
So you are claiming to be a Mutawali.
Lord, the respondent, number 5, is claiming to be a Mutawali, and in that capacity he has instituted the suit. Lord, I challenge that locus standi at
Respondent number
first.
5 instituted the suit.
Lordship.
Who are you?
Lord, I am the recorded owner.
So in the suit, which party you are?
Defendant number 1 and 2.
Pradeep Kumar Pradhan.
And Namita Pradhan.
Okay.
My lord, the plot in question, your lordship, my lord, there are several owners. Lord, I'll bring that, my lord, translated copy of the relevant document that I was placing, my lord.
You
But
do,
he has only
do one thing.
Lordship.
See, I am dismissing herein now. Why the court can waste the time? Either you go to the court number 1, land matter. Correct. Or you to the group 1.
Lordship.
Or to the court number 5, which 13 or 12.
6, my lord. 6.
6. You go to the 6.
My lord, then my lord kindly records my submission, then my whatever my lord. Lord, I'll still, my lord, pray your lordship that the action in which the tribunal has proceeded, it's manifestly arbitrary. There is no, my lord, satisfaction to the regard, my lord. It's a now, my lord, it's a settled law, your lordship, that if an issue, my lord, with regard to jurisdiction is cropped up, then, my lord, the court or the learned tribunal has to satisfy itself that it has a jurisdiction, even in one line. My lord, there's nothing on record. But I have placed, my lord, my Order 7 Rule 11. It has not been taken up since long, my lord.
Who is appearing for the other side?
Lord, we have again.
One thing, you
Lordship.
come with this translated copy of the landed property.
Lordship.
See to that. Let the other side come. Not today.
My Lord is
Let
making
the
it
matter
more
next week. Come on the next week.
My Lord, any particular date, Your Lordship?
Let's see. Yes. This is item number 12.
Yeah, I appear for the petitioner. Before or after? February.
Yes.
Abadita. Lordship, may I file my affidavit of service? This was served on February 2026.
February 2026.
Lordship, that's why maybe there is no one.
To new notice. What's the matter, Ka?
Lordship, this is a tender matter.
Which department?
Lordship, this is forest, perhaps. This is PWD.
PWD, how this court?
Because tender, my lord.
Tender might be, but that concerned department was not there. How this court?
The tender, Lordship, usually, Lordship.
Okay, Lord Counsel for the petitioner has filed the petition has filed the affidavit of service, but this court finds that the service has been affected in the month of February 2026. But subsequently, there is change in the panel of the government advocates. Accordingly, petition is directed to serve a fresh notice upon the respondents and to file affidavit of service on the next date fixed. This is the matter of 19th August.
It may retain its position, my lord.
Under the same heading. Yes, next.
Well, this is my application, my lord.
Your Lordship, I am appearing for the ROC, Your Lordship, in this matter.
My lord, may I just point out, my lord, a short background, my lord, very short. But here, my lord, I am a director in several companies, my lord. So, my lord, I am in the process of managing various companies and also, my lord, filing documents and whatever it is. Now, my lord, there is a family company, my lord, which is run by me and my brother and her and his wife. Now, whatever be it, my lord, there has been certain disputes in that company. Well, as your lordship knows, company disputes, my lord. Now, my lord, I have been continuing as director following all provisions, my lord. Suddenly, in the month of December, I find from the portal, my lord, that I have been disqualified. And disqualified under section 164 2B. My lord, this section, my lord, if your lordship kindly down at the company, sit down. But we are handing over. छोटो रखिए
164
164 2B. Well, the document is at page 73 if your lordship wants to have a look.
Yeah. I have not received the brief in my hand. Your Lordship, my learned friend is starting, but I am not having the brief in my hand, Your Lordship, and I'm read by Mr. Siddharth Bhattacharya, Your Lordship. And he's not well. Your Lordship, I'm not having the brief in my hand. Only one.
May I just point out this, Malad? I know, Malad, I'll again make that submission which your lordship
that is right.
Does not like at all. I know that, Malad. But Malad, kindly appreciate one small thing, Malad. 31st August, Malad, there is a scheme which is ending, where Malad, several penalties have been sought to by a policy to be done away with if I can file my accounts. Now, Malad, they have issued a section 164 2B saying I'm disqualified. Malad, there is nothing which says that I have not repaid any deposits or anything of that sort. Maximum, Malad, I'll come to the crux, Malad. If there can be a dispute, Malad, on the face of it, that shows 164 2B. Therefore, it has to go. Now, I do admit, Malad, 2 of the financial year annual returns, Malad, has not been filed. So, it could have been under 164 2A. 164 2A could have been, but on the face of it, Malad, it is 164 2B. So, it will have to go. Other than Malad, they did not give me the natural justice. They did not even write to me, no hearing given. So when I was just beseeching, when they come, Malad, if they can give me this, and as a matter of fact, if required, I'll file the returns now.
I think I will be in a position to do that because my lord,
Your lordship, let me then come up with the proper instruction, your lordship. That matter.
I'm proposing. So if you can, or else I would have
Take
stopped
note
for
and come with the instruction.
Proper.
Now,
Let
my
me come
lord,
up with the proper instruction, your lordship.
But kindly fixes a date to retain the position, my lord.
15 September at the affidavit of service filed by the petitioner kept with the record and counsel for the respondents.
5 minutes.
Respondents submitted she is not having the brief and she praised for direction upon the petition. So the copy of the writ application. Petition director saw the copy of the writ application to the advocate appearing for the respondent. Let the matter appear on 13th August.
13th August.
Within 10 matters.
Very good.
Grateful, your lordship.
That's it. Hey, take a basic position. Time fix for one.
Yes.
Could I get 5 minutes at 1 o'clock?
Within 10 matters. You get.
But if not within 10 minutes, I'll mention ballot. I'm sorry, Malad, but this is a very desperate situation. Grateful, man. Very good.
You mentioned we'll see. If not taken.
Well, definitely, man. I'm so grateful. So grateful.
Respondents, as per the lordship version, the lottery report in their favor. I think so.
Filing the supplementary, annexing the present report. Kindly come to page 6 once. 6, page 6 does it. Same. What is the age? Both of within age?
No, over.
Over. Both are over age. Yes, kindly see your lordship's order, paragraph 2, your lordship initiated.
Order.
Yes.
We have nothing to do with
Why
this
50
matter.
years, 8 months? Why 50 years? Why?
If the both are over age, what can be done?
Lottery, as per this law, we cannot say, we cannot allow. But as per the medical report, the lottery was given to for the medical report in your favor.
No, that's correct. But the Act says.
That is not allowed.
Act is not allowing.
Because there,
The Act says. Kindly see page. I have annexed the Act. The writ petition. It starts from page 18 and relevant page is at page
56 years and 8 months.
24. 24. Page 24 of the writ petition.
Writ petition.
25 is the section 21G.
21G. III.
Yes.
Above the age of 21 years and below the age of 50 years, women. And here she is the 51.
Yes.
And the man above the age of 21 years and below the age of 55 years. So,
the petitioner number 2 is aged about 50 years, 8 months, 7 days. An exceptional situation. Their son committed suicide.
when the son committed suicide?
Committed suicide on 20th June 2025. Thereafter, they decided 20th June 2025.
Yes. Yes, sir.
Act does not allow. But the situation of my learned friend's client, this is totally mercy up to your lordship. Pass the necessary order on the basis of the.
How it can be allowed?
This is the. Our hands are tied in this.
How the court can go beyond the statutory?
I gone through your lordship's order passed in Kamal Kumar Chandra case, but they are one of the petitioners below.
That's why one of the petitioners.
Absolutely.
No.
Then we are guided by your lordship's order.
Because 21, section 21, not debar. It is not said that the both. If any of the age, so even the lady can go singly and can adopt for the if it is fit and within the age limit. But here the problem is that both are over age. So both of the over age and the statute provide. If the statute provide whether this court can relax the statute
The power of relaxation is not there in the act.
That is
I've
the
seen.
problem.
I've seen also.
There's no proviso, there's no
No, nothing is
relaxation,
there.
there's no
Nothing is there.
condition.
But before
When-
filing the
When
petition,
you have moved, then I have also gone through. What will be the position?
at the time of filing, my lord, I checked up the
could not
act also.
find.
There was no
Even-
power of relaxation.
Even
Under
object-
compelling circum, because
even
my lord,
object
situation-
also does not provide.
situation is so great because my lord, one son committed
Go for
suicide
the adoption.
subsequently.
That is the only thing.
Yeah.
Go for the adoption. That will be the only thing you can go. Because if it is only by way of notification, the court can do.
Yes.
But it is not, it is a law promulgated under the statute.
But
that's why I directed you, and I also gone through when you have raised this question. I could not find any answer. Have you searched any such judgment or anything?
No, my lord. Can you make it not
Let
today?
not let it come after 10 days. I will also search it.
After 10
The petition has filed supplementary affidavit. Let the same be kept with the record. List the matter on 20th August. 20th August. You consult your client. We will see the adoption also. If it is, yes. You can go for the, but that is also 50, 51 and what is the age?
Age 50 years, 8 months, 7 days. And husband is aged about 56 years, 8 months, 3 days.
Then again, you will also not.
Both
CARA guidelines you will not, because
both are over aged.
103 culminated. Cumulated, if you take into consideration of the CARA guidelines, also you will not coming under that. Okay, let me see.
Yes.
Okay, next.
100.
But I am appearing for the
petitioner. 21, Malad, I am appearing for the petitioner.
Yes.
Malad, just before starting, Malad, I will point out that this matter is also similar to item number 51 of your Lordship's list.
Yes.
And also 53, though the respondent is different, but cause of action is all the same.
51
Now,
and 53.
21, 51 and 53, but 53 the respondent is different. Malad, he may not be here, Malad, because he may not know that the matter is being taken up. But 21 and 51 is same.
Okay.
Now, Malad, these matters are similar to, Malad, your Lordship had been pleased to consider a set of matters regarding, Malad, the termination of tank truck operators.
When the so-called notice is issued.
Malad, here in this case, Malad, the show cause notice, Malad, has the earlier termination has already been set aside by your Lordship once. That is at page 371.
Yes.
Malad, the show cause notice in this case was issued on 26 February 2026 at page 364.
Yes.
Now, Malad, we replied to the show cause. The oil company did not find the reply to be satisfactory, and thereafter they terminated. On 20th of March 2026.
Yes, now this court has got.
Your Lordship passed an order at page 371 setting aside the termination.
Correct.
Kindly, Malad, comes to Malad 371.
Yes.
Malad, kindly comes to page 372, paragraph 6 onwards.
Yes.
That, may I place it, Malad?
Yes.
This court finds, I'm reading at page 372.
Yes.
This court finds that the authorities have issued show cause notice on the allegation that the petitioner has not transferred the ownership of the vehicle as well as the PESO license within 4 months from the date of issuance of LOI. But now the petitioner has disclosed the document which shows that the LOI and the registration of the vehicle have already been transferred in the name of the petitioner. In view of the above, the impugned termination order dated 20th March is set aside and quashed. The petitioner is given liberty to file a supplementary reply to the show cause notice within 1 week from date by disclosing the document to the authorities, and if any reply is received from the authorities shall consider the reply along with the documents and pass reasoned order within period of 3 weeks thereafter. Now, my lord, we have filed a supplementary reply which your Lordship will find at page 374.
Yes.
Now, my lord, if your Lordship kindly takes some of the points which we have taken in the reply, thereafter I'll take your Lordship to the second termination. And then your Lordship can consider that how they have not considered my points.
Malad, my reply is starting at page 374.
Yes.
Malad, kindly Malad comes to page 375.
Yes.
Malad kindly takes paragraph 6 onwards. The letter of intent was issued in favor of the undersigned on 23rd October 2025 under the ATS framework upon compliance with the tender conditions, including submission of affidavit, caution money, and supporting documents. Due to the extension of the earlier tender, that is 2018 to 2025, the tank truck proposed under the ATS category by the undersigned continued to remain deployed and operational under the extended contract. I'm pausing here for the moment. This was the earlier contract where my seller was involved, not me, with the selling transporter retaining operational and contractual control over the vehicle. As such, the vehicle could neither be withdrawn from LPG operation nor physically handed over to the undersigned without disrupting the ongoing contractual obligations. Consequently, the undersigned obtained actual possession and control of the tank trucks in November 2025, thereby substantially reducing the effective time available for completion of the ownership transfer within the stipulated 4 months period. Thus, since the subject tank trucks was handed over to the undersigned in November 2025, all the formalities could be initiated only after getting possession of the subject tank trucks. It is pertinent to mention herein that the registration certificate and PESO license with regard to the tank truck offered by the undersigned under the ATS framework were transferred in his name on 29 January 2026 and 27 February 2026 respectively. Thus, the undersigned has complied with all the formalities within the period of 120 days if calculated from 1st November 2025. Then let's kindly skips over three paragraphs, kindly comes to page 377.
Yes.
From 11, para 11. Completion of ownership transfer of LPG tank trucks is statutory multi-layered process involving sequential steps before the jurisdictional DTO for transfer and endorsement of registration certificate, followed by mandatory amendment of the license issued by the Petroleum and Explosives Safety Organization PESO. During the relevant period, investigative proceedings at the PESO office in Mumbai had a cascading impact on the PESO jurisdictions, including Kolkata and Baroda, resulting in limited appointments and delayed endorsements. During the peak winter, this is very important, during the peak winter months from November to January, when LPG demand substantially increases across the eastern region, BPCL issued operational directions requiring continuous deployment and assured placement of tank trucks to prevent any disruption in supply of this essential commodity. In compliance with such instructions, the subject vehicle remained in active operation, leaving minimal scope for withdrawal for prolonged statutory formalities, though transfer processes were simultaneously pursued. Then 14, para 14. It is further respectfully submitted that the subject tank trucks continued to be deployed and utilized under the new tender even after the purported expiry of the stipulated period of 120 days. Such continued engagement without any objection or reservation on the part of BPCL unequivocally indicates that the said timeline was not treated as sacrosanct or as the essence of the contract. It is also pertinent to state that the subsequent to the transfer of the RC and the PESO license, in the name of the undersigned, the said tank trucks was duly inducted and accepted by BPCL for operational purposes, and the same is evident from the challan annexed herewith and marked as Annexure C, whereby the tank trucks of the undersigned was utilized and given load on 9th of March 2026, that is after completion of the ownership process on 27 February 2026, as well as issuance of the show cause notice on 26 February 2026. The acceptance and continued utilization of the services rendered by the said tank trucks even beyond the alleged deadline for compliance of the transfer process clearly establishes a conscious waiver and a relaxation of the strict compliance requirement by BPCL itself. In view of such conduct, it is evident that BPCL, having benefited from the continued deployment of the tank trucks, cannot now seek to enforce the said timeline in a rigid and mechanical manner. It is therefore most respectfully submitted that the facts placed on record clearly demonstrate that the delay if any, has arisen due to circumstances beyond the control of the undersigned and not on account of any deliberate or negligent conduct. The undersigned has acted transparently, has complied with all substantive requirements of the tender. Then, Malad, some other paragraph, Malad, kindly skips over. Malad, the termination is next at page 379. Now, kindly see, Malad, how they consider my points with regard to, Malad, the main point here. One is that there were some operational difficulties. That is why there has been a delay. Now, to that extent, they can say you knew it that it will be 120 days and there cannot, whether it's operational delay, administrative delay, I don't care. It was 120 days. But my point here is that this 120 days, Malad, was not etched in stone because, Malad, as in the reply, they kept on utilizing my vehicle. Now, Malad, kindly sees how they deal with this point of utilization of the vehicle. Malad, the impugned order starts from 379. Your Lordship, Malad, kindly be pleased to take from page 383, paragraph 6.6 at the bottom.
Yes.
Paragraph 6.6. You have contended that BPCL issued operational directions requiring continuous deployment during November to January, leaving minimal scope for withdrawal of TTs for statutory formalities. BPCL has never instructed you to refrain from completing work related to ATS, including the statutory transfer of RC and PESO license. Such transfers are legal and administrative processes carried out before the DTO and the PESO authorities. BPCL's operational directions for LPG supply, being an essential commodity, are entirely independent of your statutory compliance obligations under the ATS. These obligations are not mutually exclusive. The contention is factually unfounded and is therefore rejected. Moreover, the fact that you were able to complete the same formalities for 3 other TTs shows that delay was wholly due to the inaction and fault, your inaction and fault. Then 6.7. You have contended that BPCL's continued utilization of TTs of number so and so after the alleged deadline and after issuance of the show cause notice, including a load challan dated 9th March 2026, constitutes a conscious waiver and relaxation of the strict compliance requirements. The timeline for submitting the RC and PESO transfer documents in your name expired on 22nd February 2026. Thereafter, show cause notice was issued on 26th February 2026, which was forwarded to you by an email on 2nd March 2026. Though the show cause notice placed the TT number so and so under suspension with immediate effect, however, due to some clerical oversight and the concerned TT was not blocked in the system, this resulted in unloading of TTs even after suspension. Upon detection of the same, immediate corrective action was taken and the TT was blocked forthwith and no loading took place after 9th of March 2026. Thereafter, the said TT was never utilized for any further operations. This isolated incident arising out of the clerical error does not in any manner constitute acceptance, waiver, or relaxation of the stipulated tender and contractual conditions. It is submitted that the fact that the show cause notice was issued after a lapse of a deadline of 4 months and that the TTs were utilized even after the deadline does not waive BPCL's right to enforce the tender and contractual terms and conditions. Well, pausing here for the moment, what this means according to me is that the terms and conditions are firm when it is related to me, but it is not firm when it is related to the oil company. When the oil company intends to utilize my vehicle, then it is their clerical error, it is non-waiver, they can utilize it because of operational reasons. But when it comes to me, but I have missed the date by 5 days. My last date was 22nd of February. My PESO was completed on 27th of February. But they kept on utilizing my vehicle, and then as an afterthought, they gave the show cause notice, which was set aside by your lordship, and thereafter they gave the second termination notice. So everything is according to their own whims and fancies and requirements.
When your vehicle were transferred in your name?
Malat, the registration certificate was on 29 January 2026, which is within 120 days. And the PESO, which is the essential license here, PESO was on 27th February 2026.
27th February, and the registration?
29 January.
And the completion of the date 9th February.
My 120 days expired on 22nd February 2026. 120 days expired on 22nd February 2026.
Yes.
Now, my lord, kindly takes the last paragraph also, my lord, last three paragraphs also at 384. 6.8. You have contended, my lord, I'm at page 384. You have contended that the delay arose from circumstances beyond the control and not from any deliberate or negligent conduct. You have further contended that the TT has remained available for LPG transportation throughout and has contributed to uninterrupted LPG supply and taking adverse action would cause severe and irreparable prejudice. From the facts noted above, it is quite clear that you failed to submit the RC and the peso transfer documents within the timelines mandated by the tender conditions. The fact that you were able to complete the RC and peso transfer for 3 other TTs within the timeline clearly shows that failure to submit the required documents of TT number 0771 was due to your inaction and default. Further, the fact that all 4 TTs including 0771, you were both the seller and the purchaser as pointed out in paragraph 6.1 above. Your contention that you could not get possession of TT 0771 till November 2025 cannot be accepted. As regards the alleged irreparable prejudice to you, it is submitted that the consequences suffered by you are the direct result of your own non-compliance with the mandatory conditions that you knowingly accepted. The non-extendable nature, well, kindly mark this, the non-extendable nature, as I was submitting, of the timeline was unambiguously set out before you at the bidding stage itself. BPCL also has a public duty to enforce tender conditions uniformly and consistently, failing which the integrity of the competitive public procurement process would be undermined. And in conclusion, in the next page, my contract is terminated, caution money is forfeited, earnest money is forfeited. Now, my lord, their main contention is that it was non-extendable in nature and it was unambiguously clear. Now, my lord, I put this question to myself, my lord, if it was non-extendable, then how they could utilize my vehicle till 9th of March 2026, now hiding behind the veil of a clerical mistake. And, my lord, they rely upon, in this impugned order also, they rely upon 2 affidavits filed at the bidding stage, where a declaration was given that I will complete the process within 120 days. Your lordship will find that affidavit at page 347.
Yes.
347, which is a printed form that they give with the tender annexure 40. It is an affidavit by the seller. The seller says that I will give the vehicle for the next round. As mentioned, my lord, is at page 349. More of a no objection. And then page 350 kindly takes. It is the purchaser, meaning the petitioner before your lordship.
350,
my lord, is starting the next affidavit, which is by the purchaser.
Yes.
Here, your lordship will find an undertaking by me at page 352, serial number 16.
Yes.
That in case I fail to submit the required documents with change of name with 4 months of issue of LOI, suitable penal action shall be taken, which may include offer rejection, EMD forfeiture, caution money forfeiture, termination order, and other TTs and blacklisting of the TTs. Now they are relying upon, my lord, this undertaking given by me. My lord, but kindly see the date of this undertaking. My lord, it will be clearly visible at page 351. It is in 11th of April 2025.
It is not visible.
My lord, at 351, your lordship will find it.
That is the date of purchase of the stamp.
Stamp vendor stamp.
Yes.
My lord, they may deny that date, but the date remains the same.
We are not denying. We are not denying.
Very well. So my learned friend is not denying that this undertaking was given in April 2025. Let us forget the date. Sometime in April 2025. If that be so, my lord, at that time, I could not know that the earlier contract will be extended by 2 months. It is only because of the extension of the earlier contract that I am in this precarious position today. Now, they say it is due to my doing that I have missed the deadline. Now, my lord, I ask this question to myself. If I am vigilant for transferring the name of 3 tank trucks, what benefit will inure to me if I do not do the transfer for the last vehicle? If I'm doing it for 3 vehicles, I must be doing it for the 4th vehicle also. Number 1. Number 2, on the question of prejudice, my lord, by operating my vehicle, this your lordship has held, my lord, in one of the in the batch of petitions in one of the matters, my lord, your lordship has also held so that there is no way that the oil company is being prejudiced by this. They are utilizing the vehicle. Only thing that is happening here is that my vehicle will be stopped from running in a contract which is for 5 years because I have missed the date by 5 days when time was really never the essence of the contract. Now, my lord, in similar matters, my lord, if your lordship is kindly pleased to take one of the orders I have annexed. There are many orders, but one order I have annexed, my lord, of your lordships. My lord, that is at page 386. My lord, if your lordship kindly takes from page 387 at paragraph 300, my lord, kindly take 390, paragraph 12.
Yes. সেবকটা নেই সেটা জিজ্ঞেস করছি
My lord, may I place it, my lord, paragraph 12?
Yes, yes.
This court finds that the LOI has been issued to the petitioner on October 10, 2025. As per the terms and condition, in case the bidders fail to submit the required documents with change of name within 4 months from the issuance of LOI, suitable penal action shall be taken, including the forfeiture of EMD and caution money. In the present case, the LOI was issued on October 10, 2025. The 4 months completed on 9th of February 2026. The document produced by the petitioner in the supplementary affidavit shows that the transfer of ownership of the particular vehicle has been transferred on February 9, 2026 itself, and on February 10, 2026, the petitioner informed the authorities by way of email dated February 10, 2026, and subsequently, or kindly mark this, transfer was within 120 days. The peso license, subsequently the peso license was also transferred in the name of the petitioner, and the same was also informed to the authorities on February 11, 2026. The authorities, without considering the documents submitted by the petitioner by way of email dated February 10, 2026 and February 11, 2026, wherein the petitioner has disclosed the transfer of ownership and transferred the peso license, had issued the show cause notice dated February 26, 2026. In the show cause, it is not the case of the authorities that the petitioner has submitted the document by transferring the ownership and the peso license after the period of 4 months. It is the specific case in the show cause notice that the petitioner has not transferred the ownership of the peso license within 4 months, but that is contrary to the document produced before this court by way of supplementary affidavit. Then your lordship considered, my lord, Unitech and MP Power. Then kindly, my lord, comes to page 3892, paragraph 14. Considering the same, paragraph 14, my lord, considering the same, this court finds that the authorities, without considering the documents submitted by the petitioner on February 10 and February 11, 2026, wherein the petitioner has disclosed the transfer of ownership of the peso ownership and the particular vehicle of February 9, 2026, and the peso license on February 11, 2026. This court finds that the authorities have issued the show cause notice on the pretext that the ownership and the peso license have not been transferred within 4 months in terms of the condition of the contract. The show cause notice was issued on February 26, 2026, wherein the fact remains that the petitioner has submitted the documents on February 10, 2026 and February 11, 2026. Considering the above, the court finds that the authorities, without considering the documents submitted by the petitioner on February 10 and February 11, when the petitioner has submitted transfer of ownership of the vehicles as well as the peso license, thus the issuance of show cause notice is without any application of mine. Consequently, the authorities have also issued impugned order by terminating the contract without considering the said documents. In view of the above, this court finds that the authorities, while issuing the show cause and the impugned order of termination, have not considered the documents submitted by the petitioner, wherein it is clear that the petitioner has already challenged the ownership, it should be changed the ownership and the peso license of the vehicle. Thus, the show cause notice and the termination notice are set aside and quashed. My lord, finding that illegality, your lordship, my lord, did not remand it back to the authorities for reconsideration. Your lordship accepted the position. And what is important, my lord, in this order is that your lordship considered that the 120 days expired on 9th of February and the peso was transferred on 11th of February, which is after 2 days. My lord, in my case, it is after 5 days. And my lord, subject to correction, my lord, this order has not been challenged by the authorities. My lord, in that case, my lord, probably, my lord, my learned friend was there. This order has not been challenged. Therefore, for one contractor, they have accepted the delay of 2 days. My lord, I am repeating this because, my lord, your lordship will remember that word in the impugned order that the timeline is unextendable. Therefore, my lord, a delay of 2 days is accepted for one contractor, but it is not accepted for me. My lord, kindly seize the arbitrariness in the action.
Yes. Any further?
My lord, these are my submissions, my lord. If your lordship, my lord, is minded, my lord, to set aside the impugned order, my lord, I'll not make any further submissions. But if my learned friend intends to,
Mr. Banerjee, there are two things. One is with regard to what is the necessity of taking the undertaking, giving the undertaking by the owner at the time of the tender process.
my lord, the earlier owner is giving the undertaking that I have no objection if my vehicle is utilized further, because
No,
this
you have given the undertaking that you will transfer. So why this undertaking has been given by you?
my lord, I believe, my lord, your lordship is referring to, my lord, the annexure 41.
What is the legal sanctity of the said document which you executed, giving the undertaking that within 4 months you will complete that?
Yes, my lord, kindly, my lord, sees this. My lord, this undertaking is given in April 2025.
Correct.
My lord, at that time, the only knowledge I had that the earlier contract will complete on 31st of August 2025.
Yes.
My lord, in the meantime, what happens, my lord? The earlier contract is extended till 28th of February 2026. Your lordship will find that at page 357. Kindly, my lord, come to 357.
Yes, I am there only. 357.
Yes, my lord, at 357, fourth line. My third and fourth line. The said agreement is valid till 31st of August 2025 at 357.
Yes.
We intend to extend the existing bulk LPG transportation contract for a further period of 6 months, that is up to 28th of February 2026.
Yes.
Therefore, my lord, when I give the undertaking in April 2025, then, my lord, I do not know that the earlier contract will be extended by 2 months.
Yes.
My lord, the entire fiasco has happened only due to the fact that the earlier contract was extended for a considerable period of time and I could not get the physical possession before November 2025.
Okay.
If your lordship takes from November 2025, I have completed the entire process within 120 days.
Yes. Yes, got it.
So, my lord, what I was submitting, my lord, if my learned friend, I cannot preempt, my lord, but if my learned friend intends to file an affidavit to this, though all the documents are before your lordship, my lord, I do not know what my learned friend will say. But if so, my lord, the balance of convenience, my lord, lies in my favor. Because, my lord, if my vehicle is running, no loss will be caused to the oil company. In the entire termination order, your lordship will not find a single sentence where they have said that I have caused any loss to the company. If my vehicle runs, my lord, without prejudice to all parties' rights and contentions, my lord, then, my lord, they cannot be prejudiced in any manner. Therefore, my lord, the balance of convenience lies in my favor. Therefore, even if my learned friend intends to use an affidavit, your lordship will kindly stay the termination for the time being. Let me function without prejudice to anyone's rights and contention. Then the petition can be decided, my lord, at the final stages.
Okay.
Thank you.
My lord,
How much time will take? How much time will take?
about 15 minutes.
Any other matters are there?
1 p.m. fixed matter.
Admittedly, my lord, he's not functioning since mid-March. Today we are early August. Lordship has seen page 357, the last document shown by my learned friend.
Yes.
Lordship will kindly come to that page itself. It's his own brainchild, my lord, which has put him into trouble, my lord. Kindly see page 357, last line, last sentence. It is also noted that the new bulk LPG road transport contracts are being placed by OMCs in a phased manner, and the transporters may receive the LOI after giving the consent for this extension facility, this transition. Such transporters who receive LOI of a different OMC state would be allowed to terminate or foreclose the contract during the extended period by giving a 15-day notice to the corporation. Such foreclosure notice should be accompanied by a copy of the LOI. So this is not shown to your lordship, that his extension was optional. Kindly continue. If you agree to carry on further business with us during the extended period on the aforesaid terms and condition, please send your consent letter to this office signed by the proprietor or the authorized signatory of the firm as per draft. In case we do not receive your consent letter, so he could have very well not accepted the extension. Your consent letter for extension of the existing bulk LPG transportation contract by the aforementioned date, it shall be construed that you are not willing for the extension of the existing bulk LPG transportation contract. Now, lordship kindly sees the affidavit shown by my learned friend.
So whether this consent was given or not?
That we do not know. That he is to know. Whether he has given it in spite of knowing that an LOI is already there in his favor. In spite of that, if he has taken the chance and agreed to the extension which he had an option not to, well, the consequence will follow. Well, he cannot have both. Carry on with the extension and also have this at a later stage when the deadline has expired. Lordship, he has shown one affidavit, my lord, at page 350. 350.
Come tomorrow. It will take time.
Yes, tomorrow.
Maybe at a top, Malad, kind. But since your lordship has heard it considerably, only my learned friend is to say.
Friday I'm in little difficulty. Tomorrow I don't have difficulty. Monday, Tuesday I don't have any difficulty.
Tomorrow, tomorrow.
Tomorrow.
Malad, May Malad 21 and 51 and 53 also same. Malad subject matter is same. Malad May. These three, Malad, a bit, Malad, precedence may be given to it, Malad, so that we can complete it, Malad.
I'm not there.
Learned counsel for the petitioner has argued, concluded his argument. Police counsel for the respondent argued the matter, but due to paucity of time, it cannot be complete. Let the matter appear tomorrow within 10 matters. Police let the item number 51 and 53 be listed one after another.
My learned friend, if he says that my vehicle is out of business from March, he is in contempt of your lordship's order.
I'll say so many things, my lord, which he will not like, my lord.
Well, your lordship set aside the termination.
If come tomorrow, then I will hear.
Yes, my lord.
My lord.
Along with the item number 51 and 53. Wait a minute.
Take to the other JJ. Plus, you have written down the page number where appeals are there.
Hello, I'm for the petitioner. Appeal
item number?
Item number 67, my lord.
97.
The page is 17, my lord. This is the affidavit of service.
No, read out. Stated page.
68, page 17, my lord.
Page 17.
Page 17.
Disposal.
Yes. Disposed of.
Page 17, my lord.
Disposed of.
Page 18, my lord.
Disposed of.
Page 16, my lord.
Disposed of.
Grateful, my lord.
71.
Problem. Disposed of.
ভাই আমার কালকেও নাম দাওনি নাম কেন দিচ্ছ না সবগুলোর মধ্যে আমার নাম থাকে
Election Commission, one name will be there. Yes, next.
Pointed out.
কোথায় আছে?
আরে ওগুলো নয়, তোমাকে যেগুলো
দে,
দিলাম
দে, দে,
প্রথম।
দে।
Madam, আপনার নাম্বারটা
আছে?
দিবেন না?
Yes, disposed of. Next.
73, my lord. Page 15, my lord.
Disposed of.
Page 15, my lord.
Disposed. Disposed of.
76, my lord. Page 16, my lord.
Disposed of.
Lord, 77, my lord, I appear for the respondent statement.
Disposed of.
My lord, 78, I am for the petitioner, my lord. Page number.
Disposed of.
79, I am for the petitioner, my lord. Appeal page number, my lord. 44, 45,
Disposed
45,
of.
my lord.
এটিটাও তো তো
না, না, এটা আমার না।
হ্যাঁ নাম লেখা আছে তো
এটি না, আমার না।
আচ্ছা না
I'm for the petitioner here.
আপনারা সামনে রাখুন
I'm for the petitioner, my lord.
ঝুলি থেকে বেরালো আর করবে না কি করবে
Disposed of.
Scan করে পাঠিয়ে দিচ্ছি, আমি সব পাঠিয়ে দিচ্ছি।
আইটেম নাম্বার
আপনার 81 ব্লাড
Why 58 you mention?
58 it is
I have mentioned the page number of appeal.
Okay, disposed of.
Disposed of. Disposed
Disposed of.
I'm for the state.
Disposed of.
State in this matter.
My lord, I am
of.
84, my lord, I am for the petitioner, my lord. In this present case, my lord, there has been, this matter is, my lord, in this present case, the appeal was dismissed of without proper hearing, my lord.
Which matter? Which matter?
84, my lord.
District court.
Where is the rejection order?
Direction, my lord, is in page number 46, annexure P8.
46. Excluded from the e-roll.
Excluded, my lord. From
Not
the
no hearing.
hearing, my lord. Without proper hearing.
Record an order, separate order.
Order, my lord, has been already passed by your lordship.
The petitioner had preferred an appeal against the deletion of his name from the voter list before the appeal tribunal.
I'm praying for restoration.
On
Remitted back for fresh.
on
Fresh hearing.
on 29th of March 2026. The tribunal had excluded the appeal
Email address.
on 3rd June 2026. Learned counsel for the petitioner submitted that the petitioner could not get an opportunity of hearing to produce the document before the tribunal. And thus the tribunal has excluded the appeal, the roll. Excluded the name from the roll. Excluded the name of the petitioner from the roll.
130.
Press for the direction upon the tribunal for restoration of the appeal and after giving an opportunity of hearing to the petitioner to dispose of the appeal preferred by the petitioner. In view of the submission made by the counsel for the petitioner, the appellate tribunal is directed to restore the appeal. Requested. The appellate tribunal is requested to restore the appeal of the petitioner dated
29th March 2026 and to dispose of the same as early as possible within period of 3 months from the date of receipt. So next
85, my lord, I'm for the petitioner. I'm for the petitioner, my lord. Page number 41 is the appeal.
disposed of
For expeditious disposal.
disposed of
86, my lord, I'm for the petitioner.
disposed of disposed of
The application, my lord. The affidavit service. I'm for the
disposed of
page number, my lord.
Page number 44.
44.
88
এখানে scanned copy table আছে।
89
Also, I'm for the page number 54.
disposed of
My lord, 90, I'm for the petitioner, my lord. Page number 35 is the appeal.
disposed of
Also, I am attending the state laws.
People want to apply for the visa for kind of within 1 month.
recorded notice right 91 huh?
Madam,
The petitioner has prepared an appeal against the order of deletion of his name from the voter list before the appellate tribunal, before the HCR tribunal. And the same is pending. Counsel for the petitioner submits that due to the deletion of the name of the petitioner from the voter list, the petitioner is not getting the visa, and accordingly she pressed for a direction upon the appellate authority for disposal of the appeal as early as possible. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to dispose of the appeal as early as possible, preferably within a period of 3 weeks from the date of receipt of the yes. Disposed of
91 is 93, my lord, I'm for the petitioner, praying for expeditious disposal, page number 40.
disposed. My lord, I am for the petitioner. Disposed of
Page 20.
23. Yes.
I'm for the 95 আছে 93
Disposed of
95 to my lord, I am for the petitioner, page number 38.
which one?
96.
96 under the adjudication, I think so. Where you have prepared an appeal.
Murshidabad.
See, where is the appeal?
Murshidabad, I've checked. Murshidabad.
Give.
Your
It is not before the tribunal.
no, my lord, it is before the tribunal, page number 38.
30,
38.
38.
97, 95, 96, 96. Under adjudication.
Disposed of. 96 disposed of. Yes. 97. Appeal before where?
Only one submission. May I be allowed to be accounting one attendant?
They are allowing.
Allowing, they are allowing. The petitioner has preferred an appeal against the deletion of the name of the petitioner from the voter list. Full list of the petitioner submits that the counsel for the petitioner submits the petitioner is challenged person, physically challenged person, and he prays for a direction upon the tribunal to allow the petitioner to appear before the tribunal with one attender. In view of the submission made by the counsel for the petitioner, the appeal filed by the petitioner is disposed of by requesting the tribunal to dispose of the appeal as early as possible, preferably within a period of 3 weeks from the date of receipt of the order, and the petitioner may be allowed to accompany with one attender so that the petitioner can appear before the tribunal in person. Yes.
My lord, I am for the petitioner, page number 29. Appeal.
Disposed of
I am for the petitioner, page number 31.
disposed of
My lord, item number 99. Page number 9. Page number item number 100, page number 32. Page number 30.
disposed of 100 disposed of 101
Page number 31.
Disposed of. Disposed of.
My application. Here, my lord, more than one.
How many persons are there?
Yes, my lord, 6 persons are there. My lord, I have paid the deficit court fees under the
But
same.
they're the family members.
Yes, my lord. What happened?
How the family?
No,
members?
not the family members. They are the voters of same booth, my lord. Well, a similar cause of action. My lord, I can.
No.
Well, only one thing. My lord, here the appeal has been dismissed without giving any opportunity of hearing.
Come with the same. How the court can allow you?
Petitioner number one application can be
One
disposed of
petition.
rest.
Your lord, my lord, your lordship has been kind enough to pass similar order in identical matters. So,
No. I am not allowing the. If a family member, I might be, but the different members from the same booth or same constituency. Sorry,
same booth only.
this is not.
Then,
the,
my
this
lord,
is not the.
kindly grant me leave to. They'll kindly grant me leave to prefer separate application for 226 petition number 226 and for petition number 1 your lordship kindly pass out.
This item number
103.
103. This court find that the altogether 6 persons have filed the present date application, but they are not related to each, and they're not from the same family members. Accordingly, this court is not passing any order with regard to the petition number 226, and the petitioners number 226 is given liberty to file a fresh. As regard the prayer made by the petition number 1, the appellate tribunal is requested to consider the appeal of the petition number 1 and to dispose of the same as early as possible.
Here appeal has been disposed of without granting any opportunity of hearing.
As regard the petition number 1, the petition and counsel for the petition submit that the appeal preferred by the petitioner was disposed of by the tribunal by order dated 11/6/2026 by giving without giving an opportunity of hearing, and the petitioner was not notified the date of hearing. He prays for a direction upon the tribunal for restoration of the appeal so as to enable the petitioner to appear before the tribunal and to place the documents to justify his grievances. In view of the submission made by the counsel for the petitioner, the appeal is disposed of. The writ petition is disposed of by requesting the appellate tribunal to restore the appeal filed by the petitioner and to dispose of the same after giving an opportunity of hearing preferably within a period of 3 weeks, 3 months from the date of receipt of the order.
Well, the next matter I am praying for not today, my lord.
Why not today?
Because more than one petitioner is there, my lord, I need to take instruction.
No, I am not keeping, because once a list has been, then it will go. You withdraw with the liberty to file a fresh.
Then, my lord, similar order, my lord.
Remit back हो गया तो
No, remit back. This is for disposal. Expeditious disposal, my lord.
How many petitions are there?
Well, 14. 14 petitioners are there.
14.
My lord, needy persons, my lord.
If this court find that the 14 petitions have filed the present date application with the prayer for a direction upon the appellate tribunal to dispose of the appeal. After going to the record, this court finds that all the 14 petitions are not family members and not related to each other. Accordingly, prayer for disposal of the appeal by the petitions number 2 to 14. 2 to 14, 2 to 15 are dismissed with the liberty to file the petitioner file a fresh on the same cause of action. As regard the request of the petition number 1, the appellate tribunal is requested to dispose of the appeal filed by the petition number 1 as early as possible, preferably within a period of 3 months from the date of receipt of this order. Yes, next. Disposed of. Disposed of. Disposed of. Disposed of. Disposed of. Disposed of. 112. You're not there. Your name is there. 112.
No comment.
No appeal. There's no appeal.
Your Lordship, I don't have the copy.
See, last page. But that is not receipt. Last page, see the last page. Last annexer. Last 3 page.
Physical appeal,
But where is the receipt?
no receipt.
No receipt. Dismissed.
No receipt.
This court find that item number.
130.
This court find that
12.
112. None appears on behalf of the petitioner. No, none moved. This court find that there is no appeal. Annexed with the writ application. Accordingly, the petition is dismissed. Next.
দাদা এটা রেখে দাও।
Disposed of.
বল পেজ বল appeal अरे भाई
सर्विस ना पेज कता है
for the appellate copy दी scan copy
अरे appellate पेज नंबरটা বলতে হবে
ওতে ঢুকবি না না और जनमेंटेड चार्ज ने एवरीवन
disposed of.
disposed of যা
টিভি স্ক্যান কপি
আরেকটা আছে মনে হয়, আরেকটা আছে দেখো
Next.
আরেকটা আছে সেম
Disposed.
বাই ফাইল দাও
Disposed. Dispose of.
নাম কি নাম
appearance
Disposed of. Disposed of. Disposed of. Disposed of.
बोला
Disposed of. Disposed of. Disposed of. Which one?
জানে না
Ah. One matter and you're not carrying the brief.
analogous matters.
So,
अरे analogous पेज नंबरটা তো বলতে
124, 124.
I am for the petition.
124 122
123 ও তো বোর্ডে দেখাচ্ছে
127 127 টাও তো
Disposed of.
না না এটা সৈকত দেবে
না না কত নম্বর
125. Disposed of. Disposed of. Disposed of. Disposed of. Disposed of.
this call leave chat
Disposed of.
দাঁড়িয়ে আছে
Disposed of.
ইলেকশন কমিশন সামনে
Disposed of.
Page 22, my lord.
Disposed of. Disposed of.
और कॉपी नहीं
আরো স্পিড মতো
খালি বসে
11 113 116 ব্যবস্থা করছিল
এই
Disposed of.
পড়ে দিচ্ছি
কাউন্সেলিং শুরু হয়ে গেছে নেটে
136. Others, how many persons?
এখানে কেউ নেই
আরে তুই বল না ও আচ্ছা
Give the copy here. Otherwise, I will not sign. Disposed of. Appeal is there. Disposed of.
Right.
Disposed of. Disposed of. Others. Give.
এর মধ্যে আদার সবার টাকা দিস নি তো
Others আছে.
नहीं, ये 139
139 others.
हाँ আছে তো others. Others for Union of India.
Union of India. Okay.
হ্যাঁ ঠিক আছে one.
Disposed of.
PDV.
Page number 40.
Disposed of.
Page number 49.
Disposed of.
37.
Page number 37.
Disposed of.
43 আর 40. Or extreme.
Where is the appeal?
Page. Last page. Last page.
Last page.
নাম্বারটা বলো।
আরে কপি আছে তো
পেজ নাম্বারটা কত?
লাস্ট এন্ড এক্সেলার্স
লাস্টের পেজ নাম্বারটা বলো।
জেরক্স করতে গেছে সার্ভিস করব নাম্বারটা দিয়ে দাও স্ক্যান কপি লাগবে জেরক্স কপি না স্ক্যান কপি
Disposed of. Yes. Disposed.
145
Disposed of. One 46 koi. De. Which one?
এখানে তো অন্য নাম লাস্ট এন্ড এক্সেলার্স কি মন্ডল
পেজ নাম্বারটা মনে রাখ।
Yes. 146. জানি না টেস্ট लेके खूब घूमते हैं. Disposed of. Yes. 147 টা নাও. 147. Street.
পিটিশনার নেই এই দাও
এই নিয়ে নাও.
হ্যাঁ হ্যাঁ নিয়ে নে ফাইনালি তখন অফ করা সময় পুরো থামিয়ে
আমি আসলে কি physical copy.
No receipt.
Disposed of.
Epic number, you lordship kindly record the epic number.
Epic number আছে কি?
একবার ফাইল দাও ফেরত ওইখানে আগে হবে নালে দাও আমি আপিল না এপিক নাম্বার
SIR appeal number is there.
হ্যাঁ that will do छोड़ हाँ
Yes, next. Disposed of. Disposed of. Disposed of. 28 or 25? 151. Page number 20. Disposed of. Page number 30. Disposed of. Page number 31. Disposed of. Page number 26. Disposed of.
स्टैंड को फिल
How many persons? Item number? 55 others.
those are there 155 134
Eight. Disposed of. Yes. 155.
246
Others. They are the family members? No. So?
কতজন আছে এক বাড়িতে
154 also same. There is no family member.
not family members
150.
these are not 150 no this একজন ছাড়া বাকি সব dismiss
So, what will do? What? I am disposing of one and you withdraw to file separate application. वापस करो. The
altogether, altogether 14 persons have filed the present writ application, but they are not the family members. Accordingly, this court is not entertaining the writ application with regard to the petition number 2214. 14. The petition number 2214 are at liberty to file a fresh. As regard the prayer of the petition number 1, the writ petition is disposed of by requesting the appellate authority, appellate tribunal to dispose of the appeal preferred by the petition number 1 as early as possible, preferably within a period of 3 months from the date of receipt of this order. Yes, next. Disposed of.
Lordship, may I permitted to mention?
No one mention. What is the mentioning?
Lordship, I'm seeking file a application, file a petition.
SIR application.
Madam,
এই দুটো দিতে পারো এখন সম্প্রতি চেম্বারে কি দুটো মধ্যে দিতে পারবো
yes,
কোনো মতে
exact. But
মানে যেটা এতে 10 মিনিট লেগে যাবে ওখান থেকে আসতে 10 মিনিটে
Net UGC, where the counseling? Where is the Net UGC, where, which college, which post?
আমি যেতে পারবো স্যার যেতে পারবে
নাম্বারটা দেখি না
father and mother is
अरे urgency का वो
Which college, which post you are going to get the admission of, after the UGC clearance? You do one thing, you file in the department, come tomorrow, I will tell you.
we will not allow. Right? It is ready for filing before 48 hours without leave. It is not possible because department will require.
Not allowing. You file it today, inform, give the number to my court officer.
Milord, I have.
Come at 3, come at 3.
Tomorrow is the last day, not to immediately. Is a judgment without appeal and
So what you want?
I have an urgent matter to mention, Milord. Milord, it's an... Oh, sorry. Milord,
What? Huh? 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 What is the case? Huh? 1st of August this month. This year. Where from? New Jersey. Yes. Uh, 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 uh. Who is not allowing? Mother and not allowing the daughter to meet with the father. Yes. Then. Uh, uh. So what is your prayer? You all the matter in the writ court. The district judiciary has gone. Whichever the court is near, you file the case. So what do you want? Where is the writ petition? When you file the writ petition? 9th April 26. Incident was occurred on August 26. So where is the cause of action in April 96? Hmm. So now yesterday or this month of August, a new cause of action arose. So how you can come with the old in the old writ petition? How you can narrate the fact in the old writ petition? Hmm. To whom you want to, what prayer, what is the prayer? What is the prayer? What is the prayer? Against whom? Against whom? Mother. The private dispute can be taken by the court in the writ petition. Have you made a state authority as a party? So you made a comment to the police. So why before this court go to the other court? If the police is there, you require the assistance of the police, you go to the other court, not by this court. Correct. They will not interfere. So court has to pass the direction upon the police. Not in. You're not having the senior. You take instruction from the senior. Okay, you कर देते dismiss कर देते ठीक हो जाए. What is the order? What is the date of the order? Then কি হচ্ছে? You are not appeared. What is the number? The WP number is correct. No, say. এটা फाइल का फाइल देखो कल रखो टू बी मेंशन में रखो. Yes, call the list.
Want to raise the last order of the lordship. Lordship, in the para number 2, this kind of practice are very good. So, I'm the petitioner, I have to.
If he is raising the point of paintability, then the mentality has to be taken up first. You have to first, he has to submit what is the mentality.
That has been recorded.
Where?
Para number 2.
Hmm.
The line counting for the respondent
Hmm.
with regard to the maintenance of the
Hmm.
of the ground, that there are altogether 8 petitioners,
Ah.
and 8 petitioners have different policies, different follow action.
Hmm.
But they have filed the one. So that has to be.
Hmm.
So,
Come to the cost title.
it is 13A. I'm giving the para number 3. Is Raj Chaudhary Langan, advocate, appearing on behalf of the Health Insurance Corporation of India, submit that if the petitioner approach competent office, that is response number 3, along with the relevant documents pertaining to their policy, their grievance will be duly considered. Further submit that the issue raised by the petitioner, the cases petition will be addressed in accordance with law by the state office. In para number 4, in view of the submission made by the Rajyodhi, the petitioner are granting liberty or approach. Respondent number 3, petitioner shall submit all relevant documents pertaining to the insurance policy before then clause 5. In the event that the petitioner approach response number 3 and submit the document, response number 3 shall duly consider the matter and take appropriate action to address the sincere effort shall be made to resolve the matter in accordance with law and in line with the terms and conditions of the policy. Kindly have to order dated 1/7. It should be culminated by 19 in this order, there is a direction by our coordinate bill, which has been recorded in para number 3, the order dated 1/7. After the some of the avail the opportunity and some of for petitioner not avail the opportunity. That's why we love.
Yes, then
Kindly have a look at another method. Kind of it is the order has been passed. Then there is the question of raising any voice against petitioner in the the order of our audience. The year 2001. Honorable Justice P.K. Chakraborty. The final to para 53 of the para number 53. But then it may also be noted that the respondent here did not raise any objection regarding at the initial stage of the beginning of the state. Although this petition was moved on 22nd May 2021, presence of the Islamic Council of the and thereafter on various occasions, this petition appeared before this court and various orders were also passed time to time by this court. Although the Islamic Council of the respondent did not raise any objection regarding on the aforesaid ground or the thereafter court objection regarding reasonableness of the petition the ground of the alternative at not be undertaken at the later stage and particularly at the time of final hearing of the petition at the after a lapse of couple of this petition has been filed in the year 2019. Thereafter several other thereafter number 55. Accordingly, the objection raised on behalf of the respondent for therefore, my contention today when the petitioner avail the opportunity before the audience, then order has been passed. Several communication has been communicated between the authority and the petitioner. That kind of an objection cannot be actionable in the at least 11 hours of the final stage of that is my point.
Okay. Next.
And second argument the strategic situation when after the policy and the whole state that the petitioner alleged by the authority. That kind of situation has been created. But recently, I came to know some order by the audience where the main culprit would have another order has been given by Doctor said the principal how petitioner will get the bank account.
Come on merit. What is the merit?
I have another judgment for government that can be the order of honorable justice. Para number 10, para number 35, page number 3. The yes, Kolkata Court such objection at the 11th hour when the petitions are coming. There is the observation made by our honorable audience that where para number 35 specifically categorically says that implementation should have passed. That cannot be.
Yes, what is the what is the merit? What is the case on merit? What is the prayer?
So going to the rate of then that main culprit has been added by the direction of our honorable court, and one suit has been filed deeply first against that bill. But that established that no policyholder has been acted. But then 13 February 20, the government came to know about the bottom portion of the second page, where basic is the life insurance corporation, and then is the main culprit. They were both of them.
Yes.
That it has been passed by the court. I'm grateful to judge and that by order dated 28 that record that the life insurance corporation could not produce any document to suggest that the policy policy of the are
Yes.
that injunction got successful in by order by that has been this order. But that is in para number 70, Proxy observation is that the decision of the repetition will not prevent the repetitioner. If the repetitioner found that having a receipt of the that if they deposit at the time of purchase of the petitioner shall produce the same to the electron, and on production of the said document, the electron shall take appropriate same. In lordship observation. All of petitioner must have must become this kind of order because and there is a discussion of data the all policy that should be removed, then they can have the OTP as per direction given by the policy holder is suffer day by day, but there is a similar kind of matter that matter which is I just refer case of that is the pension matter. There is also pension. if petitioner eligible to show the original first money, that will be considered for the authority of the as per procedure. Even several matters large paid also suggests me that if you show the original first digit of the policy, then he is eligible to get the that kind of judgment it has been passed by our honorable Supreme Court. For sure that to real money that can be redemption of it. But then versus value. That lordship principle has been upheld by this judge.
Yes, which paragraph?
As page number contention of the applicant any of the forum or that's a respondent.
Which paragraph? Which page?
First page front.
Yes.
Amount and the issue accepted and because the nature of the receipt the claim which out the liability of number 25. But now circumstances reduction of the policy.
Yes, next. Revoke and withdraw the decision of purification of. Where is that order? Purification order?
First of all, that is called that policy cannot be made payment or kind of
That's why, where is the order of the purification?
has been filed by the CBI. That FIR has been acknowledged the all policies
All policy have been
in implementation of. And starting with the 57 hours.
So what has happened to the criminal case?
But that is
Acquitted.
that is there is a good situation for the policy holder. No policy holder has been added.
Now policy holder.
Has been added by the filed by the no, there is no advice by the by the policy holder are added.
So what is your prayer in the writ petition? What you want from this court?
Lordship, I am seeking direction to the
For what?
I want.
Yes, of
No, that liberty has been given to the petitioner.
no, that's correct. What is your prayer? Then I see whether what you are entitled to or what you are not entitled to. What is your case? It's okay. You are the policy holder. You have deposited the money, but you not get the benefit of that. So what is the prayer? Yes, I write thrice, but I could not understand what prayer, what is relief. Restoring their insurance policy in their original position from the date of commencement. How the court, how it can be ascertained by the court? What is the claim before the BAM, insurance company? Where F? Interim order. Final hearing, you are asking for the interim order. Yes, what is the matter? No, but problem is not Bhattacharya, but your colleague. I think you are not appearing. Was not appearing. Correct. Yes.
So if I have taken that point, after that, I will give.
Yes.
Thereafter, we find and granted as opportunity for the activity of. Whether they take any supplementary activity composition and on last position also I show at para in one all those supplement activity composition
There are so many affidavits that is mentioned. Affidavit in opposition of the respondent 1 to 9. Just ये नहीं देखो इसमें कुछ है क्या आप लोग कहाँ यस पैरा नंबर 2 yes yes I heard you please अच्छा ना affidavit नहीं affidavit no yes page yes
Petitioner has acknowledged and how she has derived this information itself is equal.
yes
Now, the other part of communication that because I will show my own statement. The most important part, what has happened to this matter is LIC is part of 3.5 crores when utilized by one of the agents, taken and converted into separate funds. And what the commissioners and this policyholder they did, we gave the amount to some agent in cash. And this big policies were generated from LIC and were handed over. So this is the problem. They are also as part not directly because they have infused and paid those amounts in cash otherwise not. Secondly, I would have given them this benefit. However, if they have paid that amount directly, agent also have paid the money. Kindly see the petition, agent has not put it. So the money that has not directly been deposited in the account of life insurance corporation. Admittedly, they say that they have made payment to the agent. Agent has not made, but how do we solve the object below? Correct. Industry doesn't run by the CPI, there is no. Who's studying about that? About that transaction. My point is that agent has not been made. Therefore, the other agent has not been made. Second is that finally, property that corporation has given. So, the original seats and however, I think we have this opposition anyone. I was relying on. And the first one, and whether I comes to case number 5. On the 8 matters, similar communication like their applications are there. And I see in 15,000 or 14, even 15,000 have clearly written to the corporation This contact such and such and arrange to hand over the person you also consider along with your observation and tracking nothing for the mode of your business and cash or check payment has to happen. Then the documents correspond to original and one copy, first premium receipt original and one copy, proposal deposit receipt original one copy, cover fee and then the pieces of bank passbook or KYC document signed respond within 7 days. This will help us to complete the original
Yes. Naturally, what is the duty of the advocate? Advocate never say truth. That's why we are here. Then
so my lord, in 2000, in fact, 2002, I think subject to correction. I think again I said subject to correction. So if my friend wants to take the benefit of issue judgment that matter was business of the compensation and my lord has so however it should have four paragraph 50 two of the above is for finding the and also for disputed question of
yes.
And particular results that my goodness has very what has happened, what was not to and thereafter what the LIC stand was and how the petitioners have went and everything and ultimately I don't kind of other coordinate as well as dismissed this petition. So my lord, to an extent this particular matter is concerned, my lord, we suffer from certain concise my argument. One is that each petitioner cannot fight one another for the there are 22 and 24. They just the contract I put such and such Punjab and Himachal Pradesh such and such made that was that you won't be able to avoid the single for a big of all the above of the trust I told and of all trust I told in certain has already above that has been by our
For inclusion or inclusion? Inclusion or inclusion?
Yes, yes. Persons having common and growing interest of controversy may be defined as by other having separate and distinct rights cannot. From the above discussion, it follows that there is a law that matter rights out of same act or transaction. Involving common question of law or practice, even if the expressive has been taken, there are also separate and distinct. there are separate fields where policies also. So it cannot come.
Yes.
Another principle and the question of as like a Michael said before, that because
First of all,
and just one line is judgment that the right of our cabinet that was not voluntarily. And this proof that he has denied the fact because he has reprogression, he has smart. I have a right to right for one thing apart from the criminal case. Apart from they are not asked for one from this. They are not asked.
So why you not joined in the civil suit claiming the share in that 3 crore?
He has other remedies.
Look, that petition has been filed in
You could have been joining the civil suit and claiming the your part of
2019 million. Kindly appreciate it. Thereafter, several order has been passed. That has been recorded. And opportunity has been given to the policyholder to avail the hearing before the authority. Yes, now, Milord, that kind of judgment, Milord, not.
anything further?
Milord, I am, Milord, grateful before your lordship and seeking direction to remove the prevention of and avail the opportunity before the authority with the original first receipt as per.
You are having the original today.
Lordship, we have. You can show me. Lordship. Lordship one, then I can file the notes of argument also. Chief Lordship one. First of all, Miller, this is the interest of the
Okay, grateful, my lord.
interest of the public. Kindly, Miller.
Concluded CAB.
Kindly allow me to file.
You want to file notes of argument? Okay.
I don't need to, my lord. I'm so grateful. Grateful, my lord.
Give to my court officer tomorrow. Yes, original fact. Huh? Item number
65 of today's list.
65 interim order. Which for the other side?
The Neil Basu is for the other side. I have intimated.
You are having the last order.
Yes. I have also pursuant to that election of the lordship. I have also served.
Though the matter is listed as item number 65, my lord.
65.
Item number 65 is on days list, but due to paucity of time, the matter could not be taken of hearing. Full stop. Counsel for the petition has mentioned the matter and submitted the interim order still today and paid for extension of interim order. And counsel for the petitioner. This court finds that the petition already enjoying the interim order, but the matter could not be taken of hearing. Accordingly, interim order is extended till 27th of August 2026 or until further order whichever is earlier.
27th
Let the
of
matter
August.
remain in the list.
Carrying for more time.
একটা কাজ করুন 10 September করি
27 আমাদের একটু ডিফিকাল্টি আছে
10 September.
Matter to you.
Let it remain in the list. If the time permit, I will take. 10 September until further order whichever is. Let the matter remain in the list. Keep with you. Keep with you.
Yesterday also this matter was.
What?
Item number 26.
Ah. Ah.
It was supposed to come within the 10 matters what you have put last order. Yesterday also it was on item number 20. Today it gone down further. Lordship, some indulgence. If it can be fixed, also Lordship would be. Lordship, any time tomorrow if it can be fixed.
My lords, I'm opposing. My lords, we are opposing that. My lords, we are being led by Mr. Ratnango Banerjee. I'm appearing for the respondent 1 and 7. They've not mentioned before mentioning. My lord, they've not put on notice. My lords, to all the respondents. My lords.
Item number 26. Yes, today already we have reached 21. Tomorrow it will come. Let me see.
My lords, may I pray, my lords, it will be taken on Tuesday if it permits, my lord. Tuesday, my lord.
Let it the remain in
All
the
right.
list. We'll see.
Very well.
Yes. Yes, any matter? Appeal side? Yes, call.
Original side, my lord, yesterday upon hearing, my lord, the parties in my matter, my lord, my lord was passing an order, my lord.
See, the court is taking up the matter on the submission of the advocate, and advocate is the court officer. If you are telling that 2 minutes matter, the court is giving 10 minutes. When the court is dictating the order, you both are starting the argument, what the court will say. Let it remain in the list.
My lord,
When the matter.
I remained
Lordship.
entirely silent, my lord.
Correct, that's why. When the
Lordship.
court
But
is
only
dictating
one
the
thing, my
matter,
lord.
you both have started the argument.
No, my lord,
Yes.
not me, my lord. My lord, only my learned friend, my lord, had made some submission. My lord, I remained silent, my lord. My lord, the result is, my lord, that the octogenarian and lady, my lord, he is suffering, my lord.
देखो उसमें हाँ डिम ना कल के मेंशन है रोक दे फाइल नहीं है तो नो फाइल बोल ही देखो ठीक है हाँ तो
My lord, my client is an octogenarian lady, my lord.
yes call the
But he
Lordship.
my lord.
The original side, may I have
Lordship.
your lordship kindly to mention a matter for drawing up and completion of your lordship's
which order
But this was the DGP passed on 10th January 2024. I was added as a partner of a partnership firm. The claim was against a partnership firm. I'm actually not a partner, my lord. Decree has been passed ex parte against me. When the execution was filed, I got to know. I immediately have come up for drawing up and completion, my lord. That is the only thing.
Lordship. Item number 29 of today's list of yours, Lordship. Appellate side, Lordship. And the order was passed by your Lordship, and Lordship was pleased to fix the matter in the top 10 matters. Lordship, every day it is getting pushed back, Lordship.
appellate side
Lordship.
appellate side is over you lost your chance yes.
My lord, only one thing, my lord, I didn't utter a single word, my lord. My
Okay,
lord,
no
I-
problem. The matter is over. Yes.
But the
Call the
matter-
list. Call the
my
list.
lordship has already passed an order, my lord, in a part, my lord.
Which matter?
General, legislative assembly matter and the.
Yes, it is there today.
Yes, item number 20, your lordship. I'm just praying before your lordship.
What is the urgency?
Urgency is that if the legislative assembly house start on
When?
17.
17.
Yes, your lordship. Kindly upload the matter.
कितना तारीख है अच्छा 5 पहले रंग 3:30 बजे घर के रहे 30 बजे को पेमेंट रहे 7th August 3:30.
May I have your lordship's kind leave to mention a matter for upgradation? It appears as item 146 today on the original site. It's been appearing on the list since 9th July. Lordship, we are a trust. The respondent bank is not letting us operate our account or withdraw funds since a few months. And that's why we are praying for an upgradation on the
What
list.
is the urgency?
The urgency is that we're not able to operate our bank account and we're not able to withdraw funds.
Operate the bank account.
Yes, your lordship. They are saying that we need to deposit the original trust deed. That is lost. We have filed a general diary.
How your bank account is freeze? Complaint made by the trustee.
Actually, the bank account was not in use for a while. When we started using it again around December, they said that they want the original trust deed to be deposited. So we told them that our trust deed is lost. We filed a photocopy with them and we filed a GD with the police station for the lost
What is the
trust deed.
prayer?
If you could just upgrade the...
Great. What is the main prayer?
The prayer is to allow our account to be closed and the funds to be transferred elsewhere. They are saying that...
That hearing is required.
Yes, your lordship. Your
Look for
lordship.
the other side.
I'm not aware, your
So
lordship.
then, how the matter can be upgraded?
Lordship, we have given a mentioning notice.
To whom you have given the mentioning notice? Some other surprise, you should notice come tomorrow, bring the other side, then we'll see to that. Come tomorrow after the further notice.
Lordship, thank you. Grateful, your lordship.
Yes, call the list. You lost your chance, sir.
I didn't.
Yes, call the list, call the list.
But today the item is item number 12, my lord. I am trying my
The
luck.
item numbers 1 to 8, my lord, I don't know what order I can pray from your lordship now.
My lord, I am praying for your lordship. These are to be mentioned. My lord, item number, all these writ applications, my lord, have been filed from time to time by the writ petition, the ideal group. They have all become infructuous.
My lord, may I make a my lord, very small and humble submission? My lord, first batch of writ petitions was filed, my lord, questioning the show cause notices, seeking to, my lord, declare me as a willful defaulter. My lord, during the pendency of that, my lord, ultimately, my lord, they proceeded to declare me as a willful defaulter. I filed a second writ petition challenging that. Now, my lord, during the pendency of that matter, my lord, they proceeded to, my lord, pass an order and, my lord, to declare me as a willful defaulter, which, my lord, your lordship gave me leave to approach the review committee. I approached the review committee, asked for a personal hearing. They gave me a right of representation, closed the right, and have passed an order. Now, my lord, I realize that I have to challenge that order. My lord, I cannot do it, my lord, before your lordship. All that I am praying is that, my lord, if my learned friends do not give effect to that order of the review committee for 15 days, to enable me to come up and challenge the order before your lordship.
Let us first take 1 to 7. Well, there is absolutely the chart which I've given up to my lord. My lord will be pleased to see, so far as item number 1 is concerned, it has become infructuous because the subsequent writ petition has been filed, written representation by the petitioners received, and the bank has dealt with the representations in a reasoned order. So that puts an end. Second one, third, fourth, same. Fifth, it has become infructuous because the subsequent writ petition has been filed, and the next one, the writ petition is dated August 28, 2026. Sixth and seventh are the same. So far as 8 is concerned, my lord, this is the one which my learned friend is perhaps referring to. My lord will see, it has become infructuous because written representation by the petitioners has been received. Bank has dealt with the representations. Cause of action no longer remains since the reasoned order has been passed. Now, by way of a supplementary affidavit, my lord, they are trying to enlarge the scope of the writ petition. They have served a copy of the supplementary affidavit to us. So today, if a hearing has been given and a subsequent order...
No, hearing has not been given. That is where I join issue. Hearing has not been given. A representation was taken on record, but hearing was not given.
Infructuous. So far as 8 is concerned, let them make a fresh application because hearing
I will. I realize that I have to challenge one of the order passed by the review committee. I will do so. All the time praying, my learned friend is correct. Perhaps I cannot seek much more here. All that I am praying is that, my lord, let my learned friend not give effect to the order of the review committee for 15 days, so that I may come up and challenge that matter. My lord, your lordship will notice one thing. In this matter, they attempted to declare my account as a fraud account. I challenged it, your lordship stayed it. Now, my lord, they've said, yes, we are sorry, you were not a fraud account. They've withdrawn that notification.
Mr. Shah, already once the review committee is already part remains in the nothing remains in the present.
I accept that. I do not. I absolutely accept that. I will have to challenge it. I will file a fresh petition. I am only praying. My lord, my prayer is very, very limited today. I only say, let my learned friend not give effect to the
days. How they can say unless the bank is agreed for that.
Well, I realize that, my lord. That is the difficulty. My lord, bank has been acting with a, my lord,
closing of this 7.
May I only say that, my lord, may I only request you lordship to record that, my lord, in view of the order passed by the review committee, my lord, this has become infructuous. I shall have liberty to, my lord, challenge the order of the review committee.
Yes, absolutely.
Naturally.
That right is always there. So that takes care of all 8 applications, my lord.
Well, I have to accept that position, my lord. I cannot argue about that. I was only wondering, my lord, that my learned friend should be, my lord, fair to me. My lord, this is, my lord, something that they've passed on the 24th of July. I didn't have time to respond. Very well, my lord, I shall come up. 28th of July is the order of the review committee.
And counsel for the respondent submits that subsequent to the filing of the writ petition, the petitioner had appeared before the review committee and personal hearing was given. And
no, personal hearing was not given, my lord.
Not given.
We had prayed for a personal hearing. Personal hearing was not given. Only a representation was accepted.
The bank has and the review committee has passed passed an order, and thus the petitioner has got a separate cause of action. Full stop. In view of the above, the WPO number 386 of 2024 is disposed
Not all these 8, all 8.
disposed of. However, with the liberty to the petitioner to challenge the order passed by the review committee if so advised by the petitioner.
I'm grateful, madam. I'm grateful.
Same order 1 to 7.
Yeah, take a disposed of.
All the 8
All
matters are disposed of.
Only
Yes,
one.
ma'am. Yes, ma'am.
With leave of my senior, my lord, of the list that has been handed up to your lordship by the bank, my lord, OD item number 5. This is, my lord, with regard to fraud declaration. So this is not rendered infructuous as a consequence of the.
Because they have challenged that again by a second writ petition.
That will stand.
200 by
My lord, that will
2026.
stand on its own feet, and as a consequence of passing of the review committee's order in the willful default matter, that is not rendered infructuous.
1, 2, 3,
You will address your lordship on that
This
separately.
is 1, 2, 3, 4. Correct. Now 5, 6, 7. 5, 6, 7.
Only on fraud.
Well, the 5 is only on fraud.
5 is fraud and OD7, my lord,
And
that
they
is
have
also fraud.
challenged fraud again.
Yes, 6.
So the first one has become infructuous.
6 is willful default infructuous. 5 and 7, my lord, are fraud declaration. Those
7 is not fraud.
7 is not fraud, willful defaulter.
So this is 1, 2, 3, 4, 6, and 7.
Yes.
6
All
and
infructuous. And
only 5 is in 5.
Well, if 5, my lord will see, is for fraud. 5, subsequent writ petition has been filed,
which is WPO
WP 200 of
Challenging
2026.
the order.
challenging
Ch-
the recent order which was passed.
Reasoned order. So WPO number 9 of 2026 also stands disposed of because the subsequent writ petition has been filed.
6 and 7 over. I make,
what is the scope of that, my lord? We will address your lordship.
My lord, kindly keep 5 separately, my lord, because here, my lord, your lordship had state the declaration of
They are
fraud,
all orders.
and then, my lord, they have also withdrawn it. So, my lord, we'll address your lordship separately on that.
Subsequent writ application being WPO 200 of 2020.
Yes, that will be.
Challenging the order
In view of
of
the
9
above,
That remains.
WPO number 9 of 2026 is disposed of.
Very well.
For item number 8 also.
What about the 8?
8 is also.
8, my lord, this is the one which my learned friend just said it is. We are
Well,
saying
8 can be disposed of, my lord.
it can be
8 also
disposed of.
Same.
Will your lordship give a
Yes.
supplementary on
What is the
record?
8? It is with regard to the willful default.
Willful
Yes.
default, yes, my lord.
Same one as 1.
As one.
Yes, my lord, same as one.
1, 2, 3, 4.
So 8 can also be disposed of.
No, 6, 7, 8.
Lordship.
My lord, kindly just keep the supplementary, take the supplementary affidavit on record, my lord. That is all that I.
Kindly the supplementary. my lord. The supplementary only bringing on record the subsequent fact that the review committee has now passed the decision.
WPA
Lordship will
8.
just take that.
OD 8 na 88 the होगा वो खाली इसमें लिखो the petitioner has filed affidavit supplementary affidavit
Lordship.
supplementary affidavit in WPA number 216 of 2026. Let the same be kept.
Very
Grateful.
grateful.
Thank you.
Number 9.
My lord, I am for the plaintiff. I have more or less completed my argument.
Yes.
Now, my lord, in this matter, there is one difficulty I'm facing. That is, there is no WS in this matter. So, there is no statement in this matter. So, I am still guessing from what direction the attacks from Mr. Datta will come to me. Now, my lord, only I will take 2-3 minutes to hand up two circulars, two regulations, statutory regulations of the IRDA, which have a bearing on the facts of this case and the stand taken by the insurance company. So, these two circulars, since this is a protracted claim, it's continuing for around 18 years, 12 years, two circulars were operative at different stages of this claim. So, my lord, may I hand up? If required, I'll
The fire insurance.
Yes, my lord. This is regarding all sorts of insurance. It's a settlement procedure.
Okay.
And my lord, I'll only indicate that and my lord, I'll also indicate from the plaint only 4-5 dates and 2 paragraphs. I'll just indicate the paragraph numbers to show that the forensic science laboratory report was never given weightage by the insurance company and why they cannot rely it for anymore in 2018. So, my lord, may I hand up the circulars? This is IRDA Protection of Policyholders Regulation 2002. The claim was of 2006, and subsequently, while the claim was pending, another circular has come into effect, replacing the previous one. That is IRDA Policyholders Protection Regulation of 2017.
Yes.
So, my lord, may I hand up, my lord? I'll indicate only list of dates and I'll make a very short submission on as to how these circulars are relevant. No, my lord, kindly.
Yes.
Now, my lord, kindly takes up the plaint once, my lord. I had submitted one convenience brief, a spiral bound.
Yes.
So the plaint will be there. But plaint is there, my lord. Kindly, so it is collated in one volume. My lord, kindly comes to page number 2, which is a list of the dates filed with the plaint. I am only indicating the list of the dates because these facts are stated in the plaint. I'm not going into the paragraphs of the plaint, my lord. And nothing is denied, my lord. Now, my lord, kindly comes to page 1. The date of fire is January 6, 2006. That is item number 4, my lord, in the serial number 4. First page, my lord.
Yes.
So, my lord, item number 4 is date of fire, January 6, 2006. Now, my lord, kindly comes to the next page, my lord.
Yes.
An 18 January surveyor was appointed. That's an admitted fact. That is item number 5, my lord. Now, the next relevant date is 2007. My lord, here the month was not indicated, but it is in 2007. Item number 8, serial number 8.
Serial number 8?
8. 2007, defendant appointed Premier Security Limited.
Investigation. Yes.
And the importance of showing this item, this document, is that this document for the first time stated that Forensic Science Laboratory has indicated it's a case of arson by using inflammable materials. Now, Forensic Science Laboratory is not on record. We have never received a copy of that. Normally, 2007. And this report also I have pleaded, I have received subsequently in 2018. Now, my lord, kindly see, this date is when Forensic Science Laboratory findings, purported findings are with the insurance company.
Forensic report is exhibited.
No, my lord, it is not there. We don't have a copy of it. Insurance company has also not brought it on record. Now, this Premier Vigilance is a replication of the Forensic Science Laboratory as stated in the report itself. Now, this report was with the insurance company in 2007, and it is handed over to me, supplied to me in 2018. Now, 2007, insurance company has the Premier Vigilance report.
Yes.
Now, kindly see, my lord. Item number 11. After 5 years, and in the meantime, insurance company continued to seek several documents from me from time to time. After 5 years, on May 23, 2012, insurance company appointed an investigator to reinvestigate the entire claim. So that shows insurance company has never relied on, and there was nothing to rely on, this Forensic Science report.
Forensic Science report of?
This Premier Vigilance. 2007, 2012, this proposal was made. Unilaterally, an investigator was appointed, whose reputation was questioned before this court. His appointment was stayed. That matter was taken into appeal. Ultimately, appeal was disposed of by an order of mutual consent, to the extent that instead of this J. Bashir, IRDA will nominate an investigator, an expert. He will investigate the cause of fire. And his area of his scope of inquiry will be limited to cause of fire, no further assessment. Yes, item 14, no, it was the appeal. Yes, my lord, 15. Yes, my lord. My lord, February 2000, in 2018, the Honorable Division Bench disposed of the appeal on the basis of the amicable, mutually consensuous order by Honorable Justice. The bench was presided by Justice Honorable Justice Jyotirmoy Bhattacharya and Honorable Mr. Justice Orijit Banerjee. That document, the order is in page 373 to 375. I'm not, my lord, if your lordship, it is in JBT, my lord, I'll show the order. Volume 3, my lord, I'm reading out the order. This is Exhibit OO.
Page?
373, my lord, it starts from 373. Exhibit O. But why this order is important? Because here the insurance company proposed before the court for appointment of an RDA nominated investigator to investigate the cause of loss. So that washes away the report of premier vigilance, on which insurance company never acted upon in all this 13 years, 13, 14 years. Now, my lord, kindly see, the court, the appellant company carries on the business of manufacturing and trading in computer parts. For that purpose, it rented a godown and stored its article of business in the godown. Its products were insured with the respondent insurance company. On 15 June 2006, 5th June 2006, a fire broke out in the said godown and the appellant suffered loss as a result. The insurance company appointed a surveyor. The surveyor filed a final report assessing the loss and demanding rupees 1.49 crores approximately. The police investigation report clearly states that the fire was a case of arson. Now, my lord, pausing here for a moment, arson is covered under fire policy. Self-engineered arson is not covered. That's fraud. But arson per se is covered under malicious damage. However, the police could not identify the person responsible for such arson, and accordingly, we are told that police has closed the case. The insurance company subsequently wanted to appoint J. Bashir and company to investigate into the matter and find out as to who caused the arson. The appellant company was aggrieved by this and approached the learned single judge by filing a writ petition being WP number 357 of 2012. The learned single judge disposed of the said writ petition. The operative part of the said order reads as follows. While accepting the basis of the claim of the insurance company that it had entertained a reasonable doubt and therefore it had justification in deciding to appoint an investigator to look into the claim of the petitioners, I direct the authorities to keep the letter of appointment in abeyance for the time being and give liberty to the authorities to apply before the regulatory authority for referring the matter to second investigator with the term of reference as indicated therein. After permission is obtained, the investigator shall conclude the entire investigation within a period of 3 months. Now, my lord, this order was partially challenged in appeal by my client on the ground that the scope of inquiry by the second investigator should confine to cause of fire, not the entire assessment, as was proposed by the insurance company. Now, my lord, we have heard Mr. Mitra, learned senior counsel for the appellant at length. Today, it is submitted that the appellant had no objection if the insurance company conducts an investigation through any other agency except J. Bashir and company. However, there should not be reassessment of damage in the garb of such investigation. Mr. Bhattacharya, learned senior advocate appearing for the insurance company in his usual fairness, submits that the object of investigation shall be to find out, if possible, who were behind the arson. Under no circumstances there will be reassessment of the damage. Accordingly, we make it clear that the insurance company shall be entitled to hold such investigation for the purpose of fixing responsibility for the arson in question and the reason thereof. Such investigation shall be concluded within a period of 3 months from the date of IRDA recommending the name of the investigator. Now, my lord, in these terms, insurance company approached the IRDA and IRDA recommended one Mr. Falguni Purokasto, who is a grade 1 surveyor, fire claim surveyor. Now, this Mr. Falguni Purokasto, IRDA nominated surveyor. He gave a detailed report with a technical, he's a technical expert. He gave a technical report as to how so much of fire could be generated, so much of heat could be generated, and the items there stored there being computer peripherals and plastic. So the fire, plastic which itself has carbon components. So this will be hydrocarbon components. So this will the fire has to aggravate, and because of this heat, the structure was the beams and iron beams and rods. These were melted and bent, so the structure collapsed. So, my lord, the report is the next page. My lord, I am not going into the report. The report clearly suggests that the fire is accidental. So this report, my lord, it is 376 to 400. The report is, and the conclusion of the findings of the expert appointed by IRDA is in the last page. Conclusion 398. 398, my lord.
Yes.
It is opined that FSL report indicating the incidence of fire as caused by arson involving human act has not been authenticated, as the report is silent over source of ignition, as also presence of specific flammable liquid as acceleration as per requirement of the indicators.
This report is exhibited.
Yes, my lord. This report is exhibited.
Exhibit?
It is exhibit II.
Yes.
Now, after this report, my lord, insurance company goes back to the Premier Vigilance report, which they have not acted upon and wanted further investigation. And that is also not in alignment with the that Premier Vigilance report, and FSL report is not also in alignment with the causes given in the repudiation letter. But taking recourse to that Premier Vigilance report, insurance company proposed to settle 75% of the claim amount. And my client said, ki 75% I'll accept as a provisional settlement. I am disputing the deduction. For that, we'll go for litigation. So the entire claim amount was held, though 75% was admitted. Now, this is my case, my lord, and now why I want. So, my lord, these are the important dates I have shown. Now, why I had handed up the regulations. My lord, I'll only show two clauses from the regulations.
Yes.
And these are statutory regulations issued under the IRDA Act. Now, my lord, kindly see in the regulation, clause 9, 2002 regulation. Clause 9, subclause 5. It is in internal page number 13, my lord, at the top.
Yes.
My lord, clause 5 of clause 9, subclause 5 of 9, on receipt of the survey report or the additional survey report. Here there have been 4 additional survey reports, clarifications to survey reports. As the case may be, an insurer shall within a period of 30 days offer a settlement of the claim to the insured. If the insured, for any reason to be recorded in writing and communicated to the insured, decides to reject the claim under this policy, it shall do so within a period of 30 days. Now, my lord, my purpose of indicating this clause is that in 2007, they had the Premier Vigilance report. Good, bad, ugly, whatever the report is. If they wanted to rely on it and reduce my claim or reject my claim, they had to do it within 30 days as per the statutory regulations. But while this claim was pending, another regulation replacing this 2002 came, that is 2017, which is even more specific.
2007?
2017, my lord. 17. My lord, I have handed up, I believe, 2 copies, 2 regulations. Yes. Now, my lord, kindly see internal page 24.
Which one? 17?
17, my lord. Internal page 25, 23.
Yes.
Now, 2017. I will copy the it is regulation number 15. Now it continues to next page. My lord, kindly come to clause 8 in the next page. On receipt of the final survey report or the additional survey report, as the case may be, and on the receipt of required information, documents that are relevant and necessary for the claim, an insurer shall within a period of 30 days offer a settlement of the claim to the insured. If the insurer, for any reason to be recorded in writing and communicated to the insured, decides to reject the claim under the policy, it shall do so within a period of 30 days. Now, same provision. So, if the insurance company had to rely on the Premier Vigilance Report or FSL report which they have in their exclusive custody,
yes,
they could have done it within 30 days from receipt of the report. But I have indicated that they have not done so. And this is my submissions, my lord. Now, I crave leave in the event it is felt necessary, after hearing the submissions of my learned friend, when he's pitted against me on the other side, I'm always on my toes,
yes,
expecting what is coming.
okay.
So I may need to rely on one or two judgments, copies of which I'll submit it, supply to him. I don't know, my lord, what is coming. So if at all required, and my lord, one more paragraph I'll just indicate, one paragraph from the affidavit. It is stated in the plain, but spiral bound book. Oh, it is here. Now, my lord, kindly takes up the spiral bound book, the compilation at page 50, my lord. Now, my lord, kindly see internal page 50, my lord.
Yes.
Hand mark page 50. Serial marking is 50. It is the affidavit of the sole witness of the plaintiff. While maintaining the stand of the erstwhile plaintiff as well as the present plaintiff, because the change of name was there due to a merger, disputing the allegation of arson, I say that loss due to arson was also covered under the said policy, which is an all-risk policy. Now, my lord, this statement is not put to test in cross-examination. It is not challenged in cross-examination. And can't be, because it is a term of the policy and there is no written statement. My lord, this is my submission. And the quantum, there's no dispute regarding quantum, my lord. And my lord, so far my claim on interest, I have disclosed a letter. I have marked it as exhibit, where while disputing the deduction and also seeking payment as provisional settlement, I had also given a notice stating that I will be seeking, you will be insurance company, in case of non-payment, insurance company will be liable to pay interest at the 2% rate, at the rate of 2% above the bank rate in which insurance company has taken loan from bank to run the business. And that is part of the IRDA regulations, my lord. The regulation is 2017 regulation.
Yes.
That portion is 10. Page 24, clause 1510, regulation number 15, clause 10. In the event the claim is not settled within 30 days as stipulated above, the insurer shall be liable to pay interest at a rate
yes,
my lord. In the event the claim is not settled within 30 days as stipulated above, the insurer shall be liable to pay interest at a rate which is 2% above the bank rate from the date of receipt of last relevant and necessary documents from the insured claimant by insurer till the date of actual payment. So there was a notice under the Interest Act, my lord.
Any further?
My lord, letter is just kindly, your lordship can, if kindly marks, it is exhibit number, it is in page number 404 of the judge's brief. And it is part of exhibit JJ. Part of exhibit JJ, my lord.
What?
The letter by which I gave a notice under Interest Act as well.
What is the exhibit?
Exhibit JJ. Exhibit JJ is a collection of documents, multiple documents. It is part of JJ. And it is in judge's brief, page 404, 405, volume number 4. The last paragraph, my lord. Volume back to them. We hereby further demand. Volume 4.
Yes.
My lord, next page, my lord, 405. I'm reading the last paragraph. The preceding paragraphs are requesting provisional settlement of the admitted liability. We hereby further demand from you interest at the rate of prime lending rate of State Bank of India as applicable on the assessed payable claim amount of rupees 1,40,76,964 for the period commencing from 1st June 2007 till the date of actual payment. Treat this as also as a notice under the Interest Act. And this letter was not responded to.
Yes.
Now, my lord, this is my submission, my lord. Now, hardly any time left, I believe, for my learned senior friend.
Yes.
My lord, the entire case of the plaintiff is that the FSL report should not be taken into account, and the claim, as has been settled on non-standard basis, should not be done. Now, the FSL report has not been exhibited by him or by me. So we need to firstly ascertain whether and how important the FSL report is, because that is the main crux of.
If it is important and if it is a full-fledged trial and you have not got the FSL exhibited and proved, how it can be taken into consideration.
Now, it has been the consistent case of the plaintiff that they never had any knowledge of the FSL report. They did not get the FSL report. It was never supplied to him. But the surprising thing is, right from the very beginning, this fire occurred on 6th of January 2006, and on the same day, the defendant appointed the first surveyor, J.B. Boda, to investigate into the cause of the fire and also assess the loss. The first report, the preliminary report, was submitted on 21st of February 2006, that is Exhibit E. Now, the final report came on 26th of March 2007.
Yes.
I believe only 5 minutes are left. In between, this FSL report came. That date is 20th of February 2006. And in the final survey report of J.B. Boda, dated 26th of March 2007, Lordship will find it at page 220, that is volume 2. This is marked as Exhibit R. Now, my lord, let us go through this.
Exhibit R is the FSL.
Yeah, no, Exhibit R is the final report of the first surveyor, J.B. Boda. It starts at page 220. That is in volume 2. ওকে ওকে পাঠিয়ে দেন, আমাকে পাঠিয়ে দেন, আছে? Yes, Lordship kindly sees at page 223 our findings. Lordship has got it, my lord?
Yes.
The building comprised 3 floors, of which the ground floor was occupied for the storage of computer parts, items, and peripherals belonging to both the Jupiter International and Jupiter International Limited. The entire building was severely affected by the devastating fire, and as a result, all the 3 top floors collapsed, including some portion of the partitioning walls separating it from the adjoining godowns. The godown building had collapsed in such a fashion that all the MS girders and joints were buckled and seen resting on the huge debris created by the falling floors and walls. As a result, the entire stock of electronic items reportedly stored in the said godown was totally crushed and covered under debris, and hence nothing was identifiable. Now, the Lordship kindly comes to page 229, 228. Point number 7, cause of loss.
Yes.
Last line, the fire brigade in the report Annexure A has stated that the cause of fire was not ascertained. Now, page 229. Second paragraph. Because of the serious nature and magnitude of the fire, a team of experts from the Forensic Science Laboratory, Government of West Bengal, visited the spot and collected some samples from the place of occurrence for their examination and submitting the report to the police for investigation. The FSL report has reportedly stated in the report that the incidence of fire was an act of arson. So, JB Boda had access to the FSL report. Next, a thorough investigation was carried out by the police to apprehend the culprits, but no one could be identified for committing arson as alleged by the FSL. The investigating police officer, after obtaining necessary legal opinion from the public prosecutor and the superior officer, closed the case on 1st September 2006, declaring FRT under section 436-34 IPC, copy of final police report attached as Annexure B. The condition number 8 of the policy states that if the fire was occasioned by the willful act of procurement or with the connivance of the insured or any claimant thereafter, all benefits under it will be forfeited. And then the last but one paragraph, since the police authorities could not establish a case of arson against the insured or anyone else, and the legal opinion and court rulings on this issue are abundantly clear, we are of the opinion that the fire was probably accidental in nature. They are also not sure, not conclusive, whether it was accidental.
That's why the law is that even the expert report, you cannot say it is to be
exactly
taken into consideration unless and until it is proved. Either you nor the plaintiff has brought the witness, examined the witness to prove any of the report.
Since it is his case, onus was on him to bring them and disprove the claim that it was by arson.
Yes.
So this finding at page 229, at page 229, my lord, establishes two things. Firstly, that JB Boda had access to this FSL report, and their conclusion that it was not only accidental, but probably accidental, not sure. It was a conjecture. And why? Because the police could not apprehend the persons responsible for that. It was an assumption.
Opinion is probably.
Yes, it was probably, not a definitive, conclusive assertion. Now, this final survey report was published, and they had assessed initially in this report at page 231, net loss payable 1 crore 74 lakhs 26,278.
Yes.
This amount was revised from time to time by corrigendum, addendum, revised corrigendum, again further corrigendum, and ultimately they had settled at rupees 1 crore 49 lakhs 83,958. That was of final corrigendum dated 21st of October 2011 at page 259 and 260. Now, this final report, Lordship sees, starts at page 220.
Yes.
Date is of 26th of March 2007. And now kindly comes to the final assessment at page 259. Same volume, my lord, 259.
Yes.
Lordship sees the date, 21st October 2011.
Yes.
And then page 260, third paragraph from the top. Accordingly, we finally assess the loss to rupees 1,49,80,958. Single line, my lord, at page, next page.
Yes.
So
149, 83, 90.
yes. So 4 years was taken by JB Boda to finalize the actual loss. In between, they were receiving information from the insured. Lordship, those documents are here.
Okay, stop here.
Just they had consumed
No,
4
stop here.
years.
Come next day.
I think tomorrow.
Tomorrow is fixed.
Tomorrow it is fixed.
Counsel for the plaintiff has concluded his argument. Counsel for the defendant has argued the matter again.
My lord,
Possibility of
after tomorrow,
let the matter appear tomorrow. Tomorrow at 3 p.m. Huh? Yes.
my lord, tomorrow, after I'll give a copy to my learned senior friend. I'll rely on a judgment of 2019 of Honorable Supreme Court on the issue of onus of proof, a burden of proof that the claim is not payable or there is a breach of condition is always on the insurance company.
And 2025 cause of harm is not.
And
See,
2000
with regard to breach condition is different thing. With regard to the quantum.
my lord, quantum is not disputed here.
Okay.
Quantum is not in dispute.
Yes.
Item number 10, specialty section 45.
Please, Your Lordship. This is my application.
Yes.
Oh, I'm sorry. This is a defendant's application for leave to file written statement. Malad. This application was filed sometime back in time, but that because that interim application was pending for judgment on admission, this application was not disposed of. However, better copy nahi hai iska. Can you give me a minute, Malad? I've just tabulated some dates. Green में नहीं छपा है. I'm sorry, my lord, it's in plain paper.
Now this is a third miscellaneous application.
Yes, my lord. This was
1 and 2 disposed of.
1 and 2 disposed of, my lord. 2, my lord, was my application for addition of party.
Now 1 was addition of party, 2
No, one was judgment on admission. 1 was judgment on admission. 2 was addition of party. And if your lordship sees the order dated 13th April 2022 at page 14 of the application, learned coordinate bench,
should not to be transferred in the
list of undefended suits. And then, my lord, this GA1 was being heard from time to time.
Yes.
24th August 2023, my lord,
Yes.
I filed this application with a copy of the written statement which was duly affirmed. Then, my lord, my application for addition of party was dismissed. GA1, your lordship's pleasure, my lord, the pleasure of the court was, my lord, coordinate benches took up this matter, but the GA3 should be decided later because if GA1 succeeds, nothing will be left. So GA3 hearing was deferred till disposal of GA1. Your lordship will kindly, there's a delay of about a year.
So this is regarding acceptance of written statement.
Yes, my lord, delay of a year and about 3 months. The principal ground taken, if I
This is not a commercial suit.
no, it is not. Principal ground taken, my lord, in the affidavit in opposition, if I have understood correctly, is that the counterclaim is barred by limitation. And that is an issue which has to be decided at the time of trial, my lord. That cannot be a ground for shutting out the written statement. Filing cannot be shut out, my lord, whatever will be decided at the time of trial, because they will get an opportunity to file an additional written statement to my counterclaim. That, my lord, your lordships have held, my lord. Now the period prescribed in the code is not mandatory because it does not give any negative consequence of the time not being complied with. Your lordships have also held that it's always better that the party is heard out on merits than and given an opportunity to deal. Those are my responses.
What is the reason given not filing the written statement?
My lord, the reasons given are that, my lord, these papers and all these documents which were there because of the transactions given, my lord. There's a COVID exclusion, my lord, which was sought. Then, my lord, these applications were pending, my lord. That is why, my lord.
1st April, you have received the writ of summons.
Yes, my lord. 1st April 21, I have received.
Appearance on 12th April 2021. Then Apex, what is Apex court order?
My lord, that is the COVID extension, my lord, because till 30th May 2022, suo moto extension. Suo moto extension takes care of it. my lord.
It's still going on that order.
Yeah. And then, my lord, not to transfer to undefinite list list.
Yes.
I don't think Mr. Dutt will seriously oppose this. There are a lot to be said on merits, your lordship. The GA1 order, my lord, your lordship has recorded. But there are reasons, my lord. They have to be brought on record, my lord. Otherwise, we will suffer prejudice, my lord.
Are you out of time? Are you out of time?
Yes.
Pause. Pause.
Not befitting Mr. Dutt's stature to pay for costs.
I did not argue anything. I can't say he won't be heard. I can't say the statement he should not be filed. If he is out of time, he should pay costs. That's it.
I leave it to you.
Thank you.
I leave it to you.
The petitioner has filed the present application being GA3 of petition in the defendant's number. All defendants.
One defendant, man, single.
Defendant, it is not yet added. The defendant number 1 has filed. Defendant has filed the present application being GA3 of 2023. Praying for. Condoning the delay in filing written statement and to allow the defendant to file written statement. Mr. Krishna Rajakra, the senior advocate appearing for the defendant, submits that the defendant had received the writ of summons on 1st of April 2021. And on receipt of the writ of summons, the defendant had entered appearance on 12th of April 2021. 12th April 2021. Full stop. Full stop. As the petitioner, as the defendant has received the writ of summons during the COVID period, in the meantime, the Honorable Supreme Court has passed an order on 10th of January 2022 in suo moto writ petition being number 3 of 2022, wherein the Honorable Supreme Court has clarified that the period from 15 March 2020 till 28th of February 2022 shall also stand excluded in computing the periods prescribed under section 23 within bracket 4 and 29 within bracket A of the Arbitration Act and the Arbitration and Conciliation Act 1996, section 12 capital A of the Commercial Codes Act and the provisions B and C of the section 138 of the Negotiable Instrument. Full stop. Mr. Thakkar submitted. In the meantime, the petitioner has filed an application being GA1 of 2021. GA1.
The plaintiff had filed.
Yes.
GA1 of 2020.
2021. Praying for judgment upon admission.
which the defendant had contested by filing affidavit in opposition. Subsequently, the defendant has filed an application being GA2 of 2021, praying for addition of parties. All the two applications were taken up by this court, and due to pendency of the said application and due to pendency of the said application, the defendant could not prepare the written statement, and as such, immediately the petition defendant has present application, praying for condoning the delay and to file written statement. For the children and counsel, record submission. Learned counsel for the different plaintiff submits it. Plaintiff submits it. The petition may be allowed subject to payment of cost. At the land counsel for the respective parties for using materials from record, this court. Where your written statement is ready?
Yes, my lord.
Record.
Yes, my lord. I have any explanation. It is affirmed on 23rd August 2023. I have stated, my lord.
Submit that. The written statement is already affirmed on
23rd August 2023.
23rd of August 2023. Accordingly, the defendant is permitted to file written statement in the department within a week from date, subject to payment of cost of rupees 10,000 to the State Legal Service Authority within a week from date.
Mr. Thakkar just said it was affirmed in 2023, meaning to say that he had done his bit. Milord, I remember, Milord, Mr. Chatterjee in a conference, not Mr. Pratap Chatterjee, Mr. Bimal Chatterjee in one conference said, I also said the same thing. It was affirmed. He said, if you write a letter to your girlfriend, I love you, and keep it in your drawer, how will he know? What difference does it make if it is affirmed? You have to give it.
Dispose of.
Grateful, my lord. Come on now. Grateful, deeply.
Now this point also came before me when the commercial. I affirm but could not.
Yes.
Yes, next.
May it please your lordship, my lord.
Contract में है हम लिस्ट मत करो ऑटोमेटिक Yes.
Madam, for the petition on the last occasion, we had cited the judgment.
Yes.
I believe my learned friend would distinguish them.
Yes.
Lordship will kindly takes. I was placing, the circular that my learned senior friend has placed, page 104. 104 of the MSME circular.
104. Yes.
Milord, if it states that, Milord, 104, Milord, 1.2. 1.2.
Page?
Milord, page 104.
1.2.
Lordship, identification of incipient stress 104.
Yes.
The circular, Milord, after identification by banks, thereafter 1.2 identification by the enterprise. In the middle portion.
Identification by enterprises.
Yes. Any micro, small or medium enterprise may voluntarily initiate proceedings under this framework if enterprise reasonably apprehends failure of its business or its inability or likely inability to pay debts and before accumulated losses to the enterprise is equal to half or more of its entire net worth. Number 3. The application for initiation of proceedings under this framework shall be verified by an affidavit of authorized person. So, what I am stressing here, the framework shall be verified by an affidavit of the authorized person. That is, he has to submit an affidavit. Now, with regard to, Milord, the 2016 circular at page 110.
Lordship,
110 kindly takes 1112.
Yes.
Milord, this 2016 circular, Milord, it gives a revive, Milord, 2015 circular, Milord, has been referred and it states that broadly this circular will be followed in consultation with 2015. Now, Milord, what I had searched in the Google that 2015 and 16 circular has been merged with in 2017. Milord, that I could not get the circular. Now, even if it takes, your lordship takes the 2016 circular, Milord, my learned senior friend has cited 3.3
Yes.
and 3.2.
Yes.
But I will state before your lordship kindly takes page 113 at 2.3.
Yes.
Milord, 2.3 is at page 113.
Just to place on record, we've cited 4.2.
I will place.
3.2 is not, it's on a consortium lending.
I will show.
It's not what we have relied on.
What is there in 2.3? Identification by the borrower enterprise. Any MSME borrower may voluntarily initiate proceedings under this framework if the enterprise reasonably apprehends failure of its business or its inability or likely inability to pay the debts, or there is erosion of the net worth due to accumulated loss to the extent of 50% of his net worth during the previous accounting year by making an application to the branch. So this is absent in this case. There is no application to the bank that he wants a voluntary MSME scheme.
Yes.
Now, Milord, may I give your lordship the brief dates of the instant case? Milord, the NPA was declared on 29/12/2023. 29 December 23.
2023. Yes.
Milord, he gave a reply to this 13-2 notice. Milord, on 14/3/2024.
13-2 notice.
Milord, I am sorry, Milord, 13-2 notice is 21 March 24. 21st March 2024.
2024. Yes.
Below the 13.3 was 13.3a. The reply to 13.2a was given at page 167.
Page.
Page 167.
No, what is the date?
Lordship kindly gives you a note. That is that dated is 17th May 2024.
70, that's 60 days.
Thereafter, my lord, the bank had replied to at page 188.
Reply bank.
Reply by the bank is dated 27th May 2024.
27 May.
May. That is at page 188.
Yes.
And thereafter, my lord, 13.4 was issued on 16/9/2024. 16 September 2024.
16 September 2024.
At page 197.
Yes. 197.
197.
Yes.
Lord, these are the dates where, according to the judgments of your lordships and also various judgments, the borrower did not ask for under the MSME scheme. Now, my lord, if your lordship takes this 13.4, at best they could have issued this letter, what they are saying at 2025, they could have requested for MSME scheme at best before 13.4 notice was issued. But after 13.4 notice was issued, they had challenged the proceeding before DRT. DRT is pending, it is at the final stage.
When they filed the application?
In 2024 itself.
Section 17 application.
It is a final stage, opposition and reply complete.
Section 17.
Section 17. Lord, we had filed a section 7 before NCLT, that is also pending. Lord, I do not have any right now instruction. What is the status of
Section
that?
7 filed by you
Lordship.
against this?
Yes.
No, see,
As of them, I do not have any instruction because today, my lord, I did not could not contact my client. So, my lord, initially there was they took time before NCLT. They praying for that the writ petition is pending. Kindly adjourn it. Lord, they knew about the NCLT proceedings. Now, my lord, the question is whether they are entitled to an MSME scheme if they belatedly ask for that. Well, all these proceedings started in the year 2023, not a whisper. In 2025, all of a sudden, in writ petition, we come up that they have issued a letter to the bank. Now, may I take your lordship to the judgments? I had, my lord, on last day, my lord, produced before your lordship the Pronis judgment. The Pronis judgment at paragraph 10. My lord, I will not trouble your lordship. I will just only highlight the paragraphs. That will be
Ronit.
lordship.
Yes.
My lord, paragraph 10. My lord, 10 says about the circular of the MSME.
Yes.
My lord, thereafter I will just paragraph 20, 21 and 22. My lord, paragraph, may I just read paragraph 20?
Yes.
Therefore, the stage of identification of incipient stress in the loan account of MSME and categorization under the special mention account category before the loan account of MSME turns into NPA is a very crucial stage, and therefore it would be incumbent on the part of the MSME concerned and also to produce authentic and verifiable documents, materials for substantiating its claim before being MSME before its account is classified as NPA. If it is not done, and once the account is classified as NPA, the banks, that is secured creditors, would be entitled to take recourse to Chapter 3 of the SARFAESI and the Enforcement of the Security Interest Act. Paragraph 21. It is also pertinent to note that sufficient safeguards have been provided under the chapter for safeguarding the interest of the defaulter borrowers for giving them opportunities to discharge their debt. However, if at the stage of classification of the loan account of the borrower as NPA, the borrower does not bring it to the notice of the bank creditor concerned that it is a MSME under the MSMED Act, and if such an enterprise allows the entire process for enforcement of security interest under the SARFAESI Act to be over, or it having challenged such action of the bank creditor concerned in the court of law tribunal and having failed, such an enterprise could not be permitted to misuse the process of law for thwarting the actions taken under the SARFAESI Act by raising the plea of being an MSME at a belated stage. Suffice it to say that when it is a mandatory obligation on the part of the banks to follow the instructions, directions issued by the central government and the Reserve Bank of India with regard to the framework for revival of rehabilitation and MSME, it would be equally incumbent on the part of the MSMEs concerned to be vigilant enough to follow the process laid down on the said framework and to bring it to the notice of the banks concerned by producing the authenticated and verifiable documents material to show its eligibility to get the benefit of the said framework. In view of the matter, we are of the opinion that the findings recorded by the High Court in the impugned order that the banks are not obliged to adapt the restructuring process on its own, or that the framework contained in the notification dated such and such as revised from time to time could not be said to be mandatory in nature, are highly erroneous and cannot be countersent. Now, my lord, may I just place your lordship another judgment, that is a South Indian Bank versus Naveen Matthew Philip and another. That is reported in 2023 SCC Online, page 43, 435. Lord, I would be relying upon paragraph 12, 13, 17 and 18.
Yes.
12, 13, 17, 18, 17 and 18. Lord, here the main contention in this judgment is if an alternative remedy is available, the writ court should not interfere. Lord, he has an alternative remedy. Lord, he had availed that opportunity, but he did not address the issue there.
Yes.
Lord, only one paragraph may I just point out to your lordship, that is paragraph 18. I will not read the entire judgment because 12, 13, 17 and 18 are Lord, what has been given by the Supreme Court. Lord, 18, while doing so, we are conscious of the fact
Yes.
while doing so, we are conscious of the fact that the powers conferred on Article 226 of the Constitution are rather wide, but are required to be exercised only in extraordinary circumstances in matters pertaining to proceedings and adjudicatory scheme, qua statute, more so in commercial matters involving a lender and a borrower, when the legislature has provided for a specific mechanism for appropriate redressal.
Yes.
Now, my lord, the next judgment I would be relying upon is Swaminath Samartha construction. Judgment কোথায় গেল?
Swami Samarth.
Lordship. It is reported in 2025 SCC online, page 1566. Para 7 and 8. This judgment was also referred by my senior friend. As has been noted above, paragraph 7. The petitioning enterprise does not seem to have ever claimed the benefit of the terms of the framework after the demand notice under section 13(2) of the Securitization Act was issued. Here in this case the same issue was involved. It is a stage of the compliance with an order passed by the Act was issued. It is a stage of compliance with an order passed by the relevant magistrate under section 14 of the SURFACI Act that this writ petition has been presented before this court, claiming benefits of the framework to restrain the respondent number 2 and its officers from proceeding further under the SURFACI Act and other enactments except in the manner contemplated under the said notification. We find the bona fides of the petitioning enterprise to be suspect. Paragraph 8. Pronounced is a decision of a coordinate bench of this court holding inter alia that the notification is binding on the lending bank secured creditors. Finding to the contrary by the High Court of the Bombay in the judgment and order under challenge in the appeal was thus quashed. Though while stressing that the terms of the framework need to be followed by the lending bank secured creditors before the account of an MSME is classified as NPA, this decision also lays stress on the obligation of the MSME by holding that it would be equally incumbent on the part of the MSME concerned to be vigilant enough to follow the process laid down under the said framework and bring it to the notice of the banks concerned by producing authenticated and verifiable documents material to show its eligibility to get the benefit of the said framework. It was cautioned that if such an enterprise allows the entire process for endorsement of the security interest under the Securitization Act to be over, or it having challenged such action of the bank creditor concerned in the court of law tribunal and having failed, such an enterprise could not be permitted to misuse the process of law for thwarting the actions taken under the Securitization Act by raising the plea of being an MSME at a belated stage. This decision, however, left unsaid something which we have explained herein above, while constructing the terms constantly to prevent the undetermining of rights that one central enactment confers by another. My Lord, thereafter, my Lord, your Lordship judgment is, my Lord, I have placed the visits are written. That is paragraph 24 and 25.
Yes.
My Lord, paragraph 24. This court finds that the petitioners in reply dated 13th August 25 informed the bank that the bank has violated the notification dated such and such by not considering the case of the petitioners in terms of the said notification, though the bank admits that the petitioner number 1 is an MSME. When the bank came to know about the order passed by the Honorable Supreme Court in the case of such and such, the bank has taken the stand that the petitioners have not requested the bank for restructuring. It is mandatory on the part of the bank that in reply, if the borrower claims benefit of the framework with reasons and affidavit, the bank is bound to look into the claim of the borrower. During the instant case, nothing is there. Considering the above, this court finds that the proceeding initiated by the bank against the petitioner is at an initial stage and there is no dispute that the petitioner number 1 is not MSME. The petitioners are directed to file its claim within a week from the date along with an affidavit and documents to the respondent number 2. If the petitioner submits his claim within a week from the date, the bank shall consider the same in accordance with the notification dated such and such. Till the final decision is taken, the bank proceeding initiated by the bank shall be kept in abeyance. My Lord, here, my Lord, in the instant case, in our case, my Lord, 13.4 has been done, everything has been done. Now he is claiming, my respect to submission, that cannot be done because the account has been classified as an NPA and the account has also been, my Lord, classified, my Lord, as a recalled asset. So now, my Lord, if he gives, even if your Lordship holds the judgment to be, if your Lordship takes the judgment to be considered, at this stage also it cannot be given. And my learned senior friend has placed, my Lord, one judgment of your Lordship, which was, they went up to appeal. In the appeal, my Lord, doers jute. They had preferred an appeal. In the appeal court, they had withdrawn. In the single bench, now if they had withdrawn that appeal, the order of the learned single bench of Justice Anuruddha Rai remains. Lord, what does the judgment says, Lord, he was granted an opportunity to deposit the dues of the bank. So let him deposit that money to the register. আপনি দেখেছেন তো এটা? আপিল তো withdraw করেছে, তাহলে তো এইটাই রয়ে গেছে। আপিল তো withdraw করেছে, তাহলে টাকাটা আপনি দিয়ে দিন। These are my submission, my lord.
Yes.
Lord, so far as my lord, the question of granting an MSME is not applicable in this case, my lord.
May I reply tomorrow? Since I just come in, the judgments is cited tomorrow, Lordship, I'll just give my reply.
Yes. Counsel for the respondent concluded his argument. Counsel for the petitioner prays for time. Chronic is adjourned. Let the matter appear tomorrow.
About same position, I want to finish it up. I came in later, so I have not read their judgments for which they are case signed.
Yes.
Well, I am for the petitioner, my lord. The outset, my lord, unqualified apology on behalf of my learned friend also, my lord. My lord, kindly pardon me, my lord. Kindly forgive me, my lord.
Where is the state officer order?
My lord, the state officer, my lord, order, my lord, at page. My lord, the warrant of possession, as I had indicated.
Warrant of possession, leave it. First you come to the state officer order.
My lord, it is of 2003 order.
Where is that?
24 my lord, it starts from, my lord.
Therefore, the
As I had indicated on the last day.
28 February 2023.
Yes, appeal ta dekhera.
Yes.
So we had moved before the district judge from that order.
Just a minute.
Fine.
So after this order, you prepared an appeal before the district
Yes,
judge.
immediately we got a stay of that.
Where is that?
And well, page 40, 48 my lord is that order. Egulo kal dekhiyeci, but page 48 my lord, P2 my lord is the annexure, my lord. The appeal is taken up for hearing on admission. Heard the that is there, my lord.
Therefore, stay is allowed.
Till the disposal of the instant appeal, my lord. The stay later further procedure of so and so is stayed till the disposal of the instant appeal. Yes, my lord. Thereafter, my lord, but the stay continued, my lord, until 2010, my lord. In 2010, the original tenant died. We needed to substitute, my lord.
2010.
Yes, my lord. In 2010, my lord, we needed to substitute, my lord. The proceedings got abated.
The tenant died.
Yes, my lord. Original tenant died. So their legal heirs was to be substituted. In 2010, we failed to do. Thereafter, the proceedings by virtue of the law effect abated. We had moved in a revisional petition, my lord. The revisional court, my lord.
Revisional order.
Revisional
court order disclosed here.
Revisional court, yes, my lord. 67, my learned junior, my lord. 67, my lord. Here, my lord. It is the May 18, 2012 order, my lord. The original tenant, my lord, Botuknath Bhattacharya, paragraph 5, he has been mentioned. My lord, if my lord come to the operative part, lordship will find, my lord. In my view, my lord, paragraph 18, 17 in at page 72, my lord, in my view, if at all Rajashri Mukherjee applies to recall the order of dated April 13, 2007 with the prayer for setting aside the abatement, and her prayers are allowed, resulting in substitution in place and state of the appellant, that Botuknath Bhattacharya, my lord, and the lease would revive, and only then could the petitioner seek their transposition as appellant with Rajashri Mukherjee as stipulated as substituted appellant. Alternatively, the petitioners, if at all, they can seek substitution according to law in place and
Okay,
state.
then what has happened?
My lord, thereafter, my lord, in 2000.
This is order of 2011.
This is the order.
These are 2012.
Yes, my lord.
Then what has happened?
My lord, thereafter, my lord, by virtue of that order, my lord, we had applied by Miss case number 412 of 2013 before the district judge, my lord. Well, that application was pending. Amid the application was pending, that
So miss
that
application is
misappli-
pending. It's still pending.
No, it was dismissed for default.
21st June.
21st, that up to my lord has been pleased to record in my lord's order of yesterday. 21st June 2025.
So you file the miss case.
Yes, my immediately we have got a restoration application. Amid that, within this, my lord,
It was
20
dismissed.
yes, dismissed. We have restored. We have filed an application for restoration. Amid that, my learned friend had gone and taken possession. No, amid that, I to bolchi. They have go, and the restoration application is pending.
So it is dismissed on
It was dismissed, my lord, June 21, 2025.
21st June 2025.
My lord.
Now you filed an application for
Restoration, my lord. That is
pending.
That is pending. Amid that, my lord. In the sometimes in 22nd of May, I'm sorry, my lord, 24th of March 2026, my learned friend has.
Where is the warrant?
My warrant at page 103, my lord. It is March 24th. My lord. No, my lord. 24th March 2026.
Where is warrant? 103.
103, my lord.
2026.
Yes, my lord. Year 2026.
What they have stated?
Kindly come to my lord.
Premises the London Gupta Land Security Officer is hereby authorized to obtain necessary police protection.
Yes, and first, my lord, kindly see at page 104, the proceedings of the city civil court that has been mentioned. Thereafter, my lord, at paragraph 5, my lord, so and so, Mr. Amitabh Dasgupta, Zonal Security Officer, LICI, Eastern Zonal Office, Kolkata, whose signature is attached so and so, he has been
the possession is
appointed. He has been, my lord, appointed.
on the basis of this, they have
On the basis of this, my lord. My lord, they had gone and my lord, taken the this actually pasted and taken in the outer wall that I have shown the photograph yesterday. At page 107 is the possession notice, but that has been given on 22nd of May 2026. When the possession was taken, this was pasted, my lord. So indeed, my lord, it is the fact that it was not served upon us. In the meantime, my lord, only my prayer here before your lordship. The original proceeding.
What is the 106?
My 106, I'm coming, immediately. 106, I believe it is before the police. Yes, my lord. They had taken, police help was, if it is required, it would be taken. On the same day, without any requirement, they have applied.
What is the date of the 107?
107, my lord, I'm coming to my lord. The very. Illegible.
What is the date of the?
Yes, my lord, it is at the bottom, my lord, left hand side, 22nd of May 2026. After the signature.
May 26, yes.
May.
So on that day, it was sealed.
Yes, my lord.
Possessions put up.
Possession and all my belongings, personal use belongings, everything remained there.
Yes, what is the submission?
But
the things are lying inside the room and we put padlock from outside. Now they want to take
back the yes.
They want to get back their goods. If they want to get back their goods, we have no objection. If your lordship pass an order that the seal will be opened by us in presence of the petitioners and they will get back their goods and then my lord again we will put the seal again and the rest of the dispute, my lord, shall be decided in the learned city civil court.
If we need to take, if both the parties we need to take an action, we have to approach
a date may be fixed by my lord on which this will be done.
A date may be fixed for that.
On
when they will be present.
Who will go to open the key? Where is the
key? Is with me.
Your key? Your seal?
The LIC's officials will go there and
they have actually given the seal. No key. Key is always with me. This is the procedure actually. But they have given the seal, my lord, with the resin and the cloth.
Seal you have put that.
Yes, my lord. Close the padlock. Yes, my lord.
Not
my key there.
Not the lock on.
Yes, my lord.
Over and above your.
No.
Upon that.
No fresh lock. No fresh lock. And that is the procedure, my lord. I should not tamper that clothing and resin, my lord, of the padlock, my lord. That is all the.
Recorded.
Yes.
The petitioner has Calcutta दिया था. अभी लिखे छोड़ देगा.
घेटे भाव पड़ बिल्कुल अटल.
Flat number 3. Flat number 3, second floor, Metropolitan Building, 7 Jawaharlal Nehru Road, Kolkata 13. State case. The Life Insurance Corporation of India has initiated a proceeding under the Public Premises Act against the petitioner. And on 28th of February 2023, the state officer passed an order for eviction of the petitioner from the premises in question. Being aggrieved and dissatisfied with the order passed by the state officer, the petitioner has preferred the statutory appeal before the Learned District Judge. Learned Chief Bench of the City Civil Court, Kolkata. And accordingly, the Learned Appellate Court has granted stay till the disposal of the granted stay of the impugn order passed by the state officer till the disposal of the appeal. During pendency of the appeal, the original tenant passed away. The petitioners being the legal heirs of the original tenant, yes.
So he stated that my lord has already recorded that.
Original tenants will not have not taken any steps to proceed with the appeal filed by the original tenant. Accordingly, the said appeal was dismissed for default. The petitioner has preferred a revisional application before this court. Before this court, being CO 957 of 2011, and by an order dated 18th May 2012, the coordinate bench of this court has given liberty to the petitioner to take appropriate step before the appellate court for setting aside the abatement order passed by the Learned Appellate Court. In terms of the order passed by the coordinate bench of this court, the petitioners have filed an application before the appellate court for setting aside the abatement and substitution of the legal heirs of the original of the appellant. Full stop. During pendency of the application for setting aside abatement and for substitution of the legal heirs of the appellant, the Life Insurance Corporation of India has issued the notice, issued a warrant of possession of the said premises, and on 22nd of May 2026, the insurance company has pasted the said notice and put the seal over the padlock of the petition in the premises. Full stop. Learned counsel appearing for the insurance company submit that as the petitioners have not vacated the premises in spite of the order passed by the state officer, and the stay granted by the appellate court has been vacated due to the appeal filed by the original tenant was abated, and accordingly the insurance company have taken appropriate step for taking possession and put the seal over the padlock of the petitioners in the premises in question. He submits that the life insurance the respondent authorities the life insurance companies is ready and willing to give the belongings to the petitioners which are available in the said premises by opening lock in presence of the petitioner. ठीक है तो? Good. He submits that if the petition is ready, then the officers will he submits that all the belongings will be provided to the petitioner by making inventory, and after taking all the belongings, the petitioners, the insurance company will again put the seal, and the subsequent consequences will be will be decided before the appellate court, where the application is pending for substitution and abatement of the setting aside the abatement order passed by the petitioner.
Consider the submission made by the counsel for the respective parties. This court find that on 25th of May, na?
25th of May 2020.
25th of May 2026, the insurance company already put the seal on the lock of the premises, but now the insurance company is ready and willing to give the belongings of the petitioner which are available at the premises. Accordingly, the insurance company is directed to accordingly. Which date can be fixed?
Your lordship may fix any date.
My lord may fix any date.
Accordingly, the concerned representative of the life insurance company is directed to hand over all the belongings of the petitioner by open the seal of the premises in question on 11th of August 2026 at 11 a.m. And at the time of taking the belongings by the petitioners, the insurance company, the representative of the insurance company shall make inventory.
May the proceedings be minute.
Shall make inventory of all the belongings which the petitioner is taking out from the premises, and also record the proceedings of the said opening of the key, making inventory, and again making inventory. ऊपर क्या बोला? Making in ऊपर बोला ना? Shall prepare the inventory, na?
Priya, we have said.
Premises full stop. After taking out the belongings by the petitioners, after making inventory, the insurance company shall again put the seal over the said premises.
I will catalog and will seal.
Put the seal over the said premises. It is further make it clear, since from the opening of the seal, taking out by the belongings by the petitioner by making inventory, and again resealing the premises shall be recorded in the proceedings, and the proceedings as well as the inventory shall be signed by the petitioners as well as the representative of the life insurance company, and the said shall be submitted before the learned district judge, before the appellate court, where the application for setting aside the abatement application is pending.
Only one thing, my lord, since the proceeding is pending, both parties has, my lord, jointly submits before your lordship that whatever action you need to take in future, but that part.
This court made it
We will
clear.
approach.
This order is passed only with regard to taking out the belongings by the petitioner from the premises, and this court has not gone into the merit of the case. On the district judge, the appellate authorities shall decide the appeal in accordance with.
And what
shall decide the application filed by the petitioner in accordance.
My lord, both parties, my lord, if they need to also take, my lord, that the proceeding is pending, my lord. I'm grateful.
That's why accordance with.
And my lord, only one thing, my lord, the 25th May inadvertently gone, the order date will be 22nd of May. That position date, my lord. It is 22nd of May 2026.
22nd May.
May 22. Yes.
And the next matter.
I'm deeply obliged, man. Grateful.
Yes. Which matter?
Next. 13.
13.
I am not troubling your lordship now.
Yes. What is the matter in 13?
That it's not concerning an endeavor to seal the account of the petitioner and not to freeze the account. The urgency is, my lord, that they have resorted to a proceeding under section 28 capital A of the SEBI Act. That proceeding, interim order was passed. That proceeding ultimately culminated. I have been exonerated of everything. On the previous occasion when the matter was.
But main thing has not been given to you. Everything you have been exonerated. Main thing has
not been opened.
That's why I'm telling.
That is, I was only saying this today. It is. Your lordship will kindly fix.
Let it be.
Fix the matter on any time. Subject to the
fix, then it will go. That's what. See, you are getting time. Once I fix matter will not taken, then I will take this serially. Let it be. I think your matter will be 2 or 3 matters. One matter. Serial number 1.
কালকে কটা ফিক্সড আছে অনেকগুলো
ঠিক তো আছে
এই দুটো
Very well.
till September all matters fixed, but we'll see to that.
Very well, your lordship.
Only one thing, I'm very embarrassed, but last time it has gone by the petition, but since the proceeding is pending, and earlier there was a interim.
Okay, I will take care of it.
Instead of petition, it would be parties, the last.
Okay, I will see.